See what we can do. What's up, everybody? What's up, everybody? My name is Marcellus McMillan. This is the Mad Church Disease channel, and we are currently about to go into the documents that have been filed by Tyrone Blackburn in response to. I said I wasn't going to do this. I'm trying not to laugh as much throughout this. So let me get myself together. Let me act like a professional here, but I cannot stop laughing. Understand, I have popcorn here. I got popcorn here. AT2, wait till you hear this. Tyrone Blackburn say he has been hacked. Y'all wait till y'all hear this foolishness. But this is going to be good. I done popped me some popcorn, and I'm gonna eat it live while I'm here with my Coke Zero, and we're gonna have a conversation. Ladies and gentlemen, I want to start off by saying thank you to every single one of you who have supported the Mad Church Disease channel over the years and continue to come and support my channel. Thank you so much. I appreciate it. You need to share this live out, get it out, put it on your social media, share it by Twitter, let everybody know that we are currently live. We're going to go into the response. Now, the judge asked Tyrone Blackburn to limit his response to 15 pages, and he limited his response to less than 15 pages, but he also added over 800 pages to his response. So his total response that was uploaded to the court and that is dated 7/19/2025 is 910 pages. You heard me correctly, ladies and gentlemen. 900. Oh, Lord, help me. And 10 pages. Ladies and gentlemen, I'm going to attempt to go through the initial response of Tyrone Blackburn. If you cannot see the top of this, but if you can, if you make your screen larger, you will see it says I'm on the first of 910 pages. And you know what? I am Courtney. He is petty. He's so petty. But no, you know what it is also? He is thumbing his nose at the judge. He is literally thumbing his nose at the judge. And I'm going to give you some different scenarios as to what I feel is probably going to happen in this situation. But I want to take my time here for just a moment, okay? If y'all will allow me. Let me remind y'all of some stuff. Let's set a foundation. This case was filed. The complaint was filed November the 25th of 2024. Ladies and gentlemen, it is now July 19th of 2025. All right. We have had all kinds of motions. We have gone back and forth. The judge has even filed some motions. They filed for an anti-slap. If you all remember the anti-slap, the judge slapped down his anti-slap. All sorts of things have transpired throughout this entire situation. You're going to learn something in this filing that you probably were unaware of. And I was unaware of it because it's bull jive. But we're going to learn something. We're about to learn something today. Let us prepare our hearts and mind as we get ready to read the word of the situation here. And I am going to be eating my popcorn as I'm reading this. Y'all pray for me and bear with me. That's all I'm gonna say. I'm gonna try not to smack in your ears, but I'm gonna be eating my popcorn because this is popcorn worthy. If you don't have no popcorn and you want to take a few minutes, I'm gonna try to give you a few minutes before we actually dive right in. Run, Rudolph. Get your cell phone, carry your cell phone down to your kitchen, run over there, pop you some popcorn and get you a drink. Because this is gonna take a while. No, I ain't about to read no whole 900 pages. Now, you know better than that, Courtney. Now, y'all know I ain't going to read no 900 pages. I'm going to read you the most pertinent stuff, and we're going to skim through the 900 pages. I'm going to skim through them so you could see what it is, but we ain't going to read all of them. Okay, because I'm going to tell you right now, in this 900-page document, Tyrone Blackburn is an asshole. I'm sorry, y'all. Excuse me, saints, because that's the only word I could use. Tyrone Blackburn is an asshole, in my opinion. Okay. In one of these pages, he literally put a calendar. I think he was trying to tell the judge that the judge didn't give him the allotted time that he was supposed to have in order for him to properly respond. So he's essentially telling the judge, you didn't get your days right. And then he files a day later than what the judge actually said he had to file, which was by the 18th. He files it on the 19th. Because I was checking this all night, even past midnight. These documents was not filed last night. What's he gonna say? He sent them to the court, and the clerk didn't upload them into the 19th. Okay, if that's what he's gonna try, that's not gonna work. Now, for those of you that are new to my channel and new to me, and you may didn't know this, I used to work for a law firm called the Disability Group. Now, the Disability Group was at one particular point was on the Income Inc. 500 fastest growing law firms in the country. The Disability Group was bought out by Bender and Bender. You might have heard of Bender and Bender because they used to run commercials all throughout the whole United States. My job at the law firm, my official title at the law firm was case analyst. That's what my job was. I was a case analyst. They wanted to make me, and I'm trying to give y'all some time to get y'all drinks and y'all popcorn. They wanted to make me a case manager, but it was going to be what's called a lateral move. When you make lateral moves in corporate America, they increase your workload, but they don't increase your pay. I did not want to make a lateral move, so I stayed in my regular position because I was going to be able to make the same amount of money and not have double the caseload. Let me plug in my Ethernet cord. Hold on. That way we'll have a more stable connection. All right. So they wanted me to take on about my monthly caseload as a case analyst. We were bringing in a lot more cases, but my caseload was about 20 cases a month. They were literally trying to give me 50 cases a month as a case manager, that I would have to manage 50 cases every single month, and make sure that those cases were ready and prepared to go to trial. Case analysts and case managers and people like that are typically, in some other scenarios, are referred to as paralegals. You're a legal paralegal. That's what you are. You've been deputized normally when you work at a law firm, but they give you a fancy title, but you're literally a paralegal. That's what you're doing. So let me tell you, when I look at these papers, now I'm not a lawyer and I'm not an expert. So I take my limited knowledge of what I learned when I was at the law firm. And Daryl has worked at several law firms. I know it's hard for y'all to believe, but Daryl has worked at several law firms. So when Daryl and I speak about these things, we're normally speaking from a little bit of experience of what we experience with the limited knowledge that we have. Okay. I want to start off by saying this today. I thought that only financial planners and financial people, hey, Battles, hey, Jimmy, listen here, Jimmy Battles, we need to talk too. You and I need to do a live together. We need to do a live together. We need to talk. But anyway, I thought the only people that had a fiduciary responsibility to their clients was financial advisors. But when I looked it up, all attorneys have a fiduciary responsibility to their clients, and they use that term that you must act in the best interest of your client to meet your client's needs, etc., etc. And I wrote it down in the description. What I have in the description of this video is the actual legal terminology. I went and looked it up, and I copied and pasted, which is what Tyrone Blackburn has been doing, and that's what's got his ass in so much trouble. But y'all, you didn't hear that from me. I copied and pasted and put the legal definition in the description of this video. So pay attention. So hopefully you have gotten your drink, you've gotten your popcorn, because this is a popcorn worthy reading. Let us start, ladies and gentlemen. Let us read the blessing of the Lord. Let us read the word of the Lord as by way of Tyrone Blackburn. And if this don't get your goat, and if this don't make you understand how stupid Tyrone Blackburn is, I don't know what else will. Now, these are my opinions, ladies and gentlemen. They may not be your opinions, but these are my opinions. Tyrone Blackburn is an idiot. He's an idiot. And if I had him as an attorney, God, oh Lord forbid, God forbid, I don't know what I would do. Y'all ready? Let us read. Read. Y'all know back in the old church, they would just holler out, somebody read. Here we go, ladies and gentlemen. You ready? Let me cross my leg. This memorandum is submitted in response to the court's June 28th, 2025 order to show cause regarding potential violations of Federal Rule of Civil Procedure 11 in connection with the motion to dismiss and supporting memorandum filed on behalf of defendant Duane Youngblood. The undersigned respectfully submits that any errors in the cited materials were the result of inadvertent misquotations and citations, misattributions stemming from newly adopted product upgrades for LexisNexis and Westlake Law research tools. Did you understand what he just said? Let me break it down for you. The computer did it. The computer made me make all these mistakes. It was the computer. The computer did it. Now, when I first read this, I hollered. When I tell y'all I hollered, because let me tell you how churchy I am. And I'm going to be laughing throughout this whole situation. So you just wait. You just wait. Mary, you ain't heard nothing yet. Wait. Now, for those of you who are a little bit older, the Clark sisters used to have a song back in the day on their Heart, I believe it was on the Heart and Soul album, called Computers Rule the World. Y'all may not remember this. The Clark sisters used to have a song called Computers Rule the World on their Heart and Soul album. And when I first read that statement, the first thing that came to my mind was the Clark sisters' Computers Rule the World. Because back in the day, all the saints used to be so afraid of computers, right? Computers go get us. Computers go get us. So essentially, ladies and gentlemen, Tyrone Blackburn is saying, and I'm going to read it again, just for the sake of the people in the back that just didn't understand. He said he submits that any errors, if there were any errors in his paperwork or his cited materials, they were the result of inadvertent misquotations, citation, misattribution stemming from newly adopted product upgrades for LexisNexis and Westlaw legal research tool. While those upgrades offered efficiency, they also introduced vulnerabilities in the citation and quotation process that I did not fully understand at the time of the filing. The computer did it. And even if it made an error, and it had misquotations and it had different citations, and the process that I was not fully able to understand at the time, Your Honor, I didn't understand how to use the software. That's really what he's saying. I just want to let y'all know. That's literally what he's saying right here. I did not fully understand at the time of the filing. I didn't know what I was using. So if any reason that it is wrong, it's because I didn't understand the software and the software was wrong. The software did it. Y'all pray my strength in the Lord. Pray my strength in the Lord. Y'all ready? Let's keep going. Now, I'm going to tell you something. Before I get into the deep end of this, I'm going to give you 3 scenarios at the end of this video. I'm going to give you 3 predictions on what's going to happen. Because over here, we've been telling you what's going to happen. I'm going to tell you, based on my own past experience with attorneys and with the law firm, I'm going to tell you what's going to happen to this man. But let us continue, ladies and gentlemen. Are you ready? Here we go. Importantly, I was in the process of correcting these. Now, I want y'all to listen, pay very close attention to this. Lord help me. I don't know how I'm going to get through this. Okay. Importantly, I was in the process of correcting these issues during the 21-day safe harbor period provided under Rule 11 when I was involuntarily terminated as counsel. Now, what's wrong with this statement? Where y'all in the chat? Tell me what's wrong. Moni and Christine, you're not allowed to answer because y'all already know. Tell me in the chat, you all, what's wrong with that statement? Y'all tell me. If y'all been listening and following along with what we done told you and showed you, what's wrong with this statement? Put an answer in the chat. I want to see your answer. Who's the first one? Go. Moni and Christine, you're not allowed to answer. You aren't either, Daryl. You're not allowed to answer because y'all already know the answer. Come on, y'all. I want to see the rest of y'all in the chat. Tell me what's wrong with this statement. Importantly, I was in the process of correcting these issues during the 21-day safe harbor period provided under Rule 11 C2 when I was involuntarily terminated as counsel. You say Daryl just told you. Did he write it already in the darn thing? I hope Daryl didn't. Okay. Well, Mary, there we go. 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 First thing's wrong, ladies and gentlemen. First thing's wrong with this statement is he says he did not have an opportunity to finalize the corrected memorandum of law. Let me go back. He was in the process of correcting his issues during the 21-day safe harbor period under the rule. He said he was involuntarily terminated as counsel. Now, wait a minute, ladies and gentlemen. Didn't Tyrone Blackburn ask to be dismissed from the case? Wait a minute, AT2. Wait a minute, AT2. Now, see, y'all don't even remember this stuff. Chat, those of you who are listening and watching, did he not file paperwork to be removed? Did he not? Did he not ask the judge to take him away from the case? Now his excuse is he was involuntarily terminated as counsel. When did y'all find out that he was involuntarily terminated? When did that happen? When he asked to be removed from the case, and I feel like I'm yelling. I don't need to be talking this loud. When he asked to be removed from the case, didn't the judge tell him no? I'm just trying to help y'all. I'm trying to help y'all. Okay, listen to me. This is a whole lie, and you got to know how to decipher the lie. He's saying he was involuntarily terminated, meaning Duane Youngblood fired him without his knowledge, but he was still filing paperwork on behalf AT2 of Duane Youngblood. Makes no sense whatsoever. I'm gonna keep reading because this gets worse. Let's go. Now he says it was his intent to do so. Now, if you're taking notes, he says he was going to correct all of the issues that he's been having with all of his misquotations of the law and his cut and paste with ChatGPT. He was going to fix all of that during the 21-day safe harbor period for the Rule 11. He was going to fix it. That's what he said. He was going to fix it. But he was terminated. He was involuntarily terminated as counsel. So before he had a chance to fix it, Your Honor, this is what he's trying to tell the judge. And I was forced withdrawal occurred before I could complete my professional obligation to amend the record. I want y'all to understand something. Tyrone Blackburn is saying he was going to fix all of the mistakes that he had made, but before he could fix the mistakes, he was terminated. Now, let me go ahead and tell you why that's not going to work. Tyrone Blackburn, as far as last year and the early part of this year, TD Jakes' attorneys has been telling you you were misquoting the law and you were misrepresenting and leaving out whole parts of the case law. Not only did they correct you in their refilings, they told you the parts that you were messing up with, and they cited for you the parts that you left out and you were not doing properly. But instead of you going back and checking the work that you had done, you doubled down, in my opinion, on your bull jive. And you kept refiling paperwork and refiling paperwork. And they kept having to come back to tell you that even the filings that you were making then were inaccurate and they were wrong. Okay. So according to Tyrone Blackburn, ladies and gentlemen, he was on his way to turn in his homework before. This is the equivalent. I was about to turn in my homework, but the only reason why I didn't turn in my homework, my dog ate it. The dog. Your Honor, I was about to fix all of my mistakes, Your Honor, but before I could fix all of my mistakes, Your Honor, they fired me. And you're going to see him in here. Wait a minute. You're going to see him in here in just a minute. You're going to see something. I'm going to point it out to you. Let's keep going. I'm just saying, this comes with commentary. Let's go, ladies and gentlemen. Listen what he says. I do not dispute that the motion contained editorial and citation deficiencies. Y'all know what that means right there. I do not dispute that can I be myself in this live for just a minute? That the shit that I put in there was incorrect. However, oh, this is too good for me. However, respectfully submit that these errors were not made in bad faith, were not intended to mislead the court, and were never intended to evade scrutiny. In other words, Your Honor, I submitted all of these errors and I did it in good faith. I didn't know what I was doing, Your Honor. I had no clue what I was doing, Your Honor. I wasn't trying to mislead the court or mislead everybody. And I wasn't even trying to not evade scrutiny. But wait a minute, Tyrone. When you kept filing your responses, you kept name calling TD Jakes' attorneys and saying all kind of stuff, talking about they must have fell and bumped their head, or what was it? They had a bad dream, or they were having hot flashes, or what did he say in that court case? I don't even remember. Y'all remember? He was saying all that old stupid stuff. Oh, Your Honor, I didn't do this to evade the scrutiny of the court. Listen what he says. I take full responsibility for my what? For my what, ladies and gentlemen? What's the word? Failure to thoroughly verify quotation source throughout the newly adopted product upgrades for the LexisNexis and Westlaw legal platform. I take full responsibility for what? My failure. I just want to tell the saints, keep in mind, saints, there is no failure in God. There is no failure in him. The man failed. But now he's blaming Westlaw and the legal platforms and LexisNexis for his complete failure. Now, let me tell you why this is not going to work, ladies and gentlemen. TD Jakes' attorneys filed response after response after response, telling this man that he was misquoting the law. Even at one point, ladies and gentlemen, if you all remember, and if you've been following my channel, you remember that he even misquoted the judge, and the judge got angry. Y'all remember? Y'all paying attention over here when I was reading this here documents over here? Y'all remember he misquoted the judge. Do y'all remember that? And the judge got mad. That's one of the reasons why he had to write this here paper. And that's one of the reasons why he gonna have to show up in a couple of days, I believe by next Friday, in front of the judge. Because see, that's not the end of it. This ain't the end. This ain't the end. So in other words, Your Honor, the computer did it. The computer did it. He said, and I acknowledge the seriousness of the court's concerns. I request that those concerns be viewed in the context of the entire matter. Now, here's what he wants the judge to do, ladies and gentlemen. He wants the judge to surmise and to take all of the things that he is saying in light of all of the other things that have transpired. And he's going to tell the judge, Judge, I need you to view this in the entire context. But I'm going to tell you, part of viewing this in the entire context is also to view the fact that you have been told over and over and over again that you were misrepresenting the law and you were misquoting the court, in my opinion, and you should have considered those things. And I think that in order for the judge to be looked at to do his job efficiently and effectively, he must surmise the fact that you had ample opportunity to correct your behavior in which you never corrected. And according to what I looked up today, you have a responsibility to your clients when you submit this information to the client is to do so and to proofread your work and to go through the process of proofreading your work. But listen, I don't believe Tyrone Blackburn is a practicing attorney. I think Tyrone Blackburn is, in my opinion, is an ambulance chaser. He just goes and sees who he can extract money from. He never expects to practice law. And because if you're going to practice law, you must have people who can proofread and make sure that the law that you are citing and the things that you are citing inside of the case law actually meet the qualifications for the court, for the case in which you are trying to represent that case law in. Oh God, I'm working here. I'm working here. I know I'm working good here. There's some good teaching here. Hidobo sha, hidobo say, if I say so myself. Okay, let's move on. But he admits, number one, ladies and gentlemen, understand, it was a failure. So he failed to do it, and he admits it. But he wants the judge to look at it in the entire context of the matter. I want you to hear me, ladies and gentlemen. If I was the judge and I was looking at it in the proper totality of its context, I must consider the fact that you had ample opportunity to correct your behavior, and you were told on numerous occasions that you were misrepresenting the law, you were misquoting the law, and that should have led you through the process of going back to check your work. Ladies and gentlemen, I know I'm not a lawyer, and I don't consider myself to be an expert on legal matters. But even in school, when we had complex math problems, go with me. Y'all remember when we was doing fractions and multiplication, algebra? Y'all remember the teacher used to tell us something? We would go up there with a piece of paper and we had solved the problem, but we didn't show our work. Y'all remember that? Y'all remember when you was trying to be slick and you would give the teacher your paper and the teacher would say, how did you arrive at this conclusion? Oh my God, I'm teaching good today. Listen here, Lynn. You had to figure out the lowest common denominator and you had to show proof as to how you arrived at that number. Tyrone Blackburn, may I suggest to you, sir, that a part of the judge considering the whole context of this matter, you must show the court how you arrived at these conclusions. The wrong ones, and now how you have arrived at the right conclusion. You're going to have to show the court how you arrived at these erroneous concepts that you was considering to be the totality of the law. I'm just saying. Shall I continue? Let us continue, ladies and gentlemen. He says, I request that those concerns be viewed in the context of the entire matter. This was a good faith effort to file a procedurally sound and meritorious motion, followed by a good faith effort to correct what I later learned were citation-related mistakes. If you're taking notes, ladies and gentlemen, I want you to pay attention to what I'm saying, because I already know how this Bing footage is about to go. I'm going to tell you in a minute, but pay attention. Daryl, you make me sick. I've been laughing all day, Daryl. Please stop, because you know my stomach is already hurting. Please, please, please. He says, and Mary, you get ready to come up here because I want to hear from you. He says, I request that those concerns be viewed in the context of the entire matter. He says this was a good faith effort to file a procedurally sound and meritorious motion, followed by a good faith effort to correct what I later learned were citation related mistakes. If you're taking notes, ladies and gentlemen, write this down. The judge is going to want to know, at what point, Tyrone Blackburn, did you realize you had citation related mistakes? That's going to be a question that will be posed to Tyrone Blackburn. Tyrone Blackburn, you will not be escaping this. I won't let you know that. Hallelujah. Y'all pray for me because this is going to tickle my soul. That will be a question that will be posed to Tyrone Blackburn. Okay. At what point did you realize that you made those mistakes? Second question. At what point did you make corrective actions or behaviors to ensure the fact? Now, I want y'all to understand what Tyrone Blackburn is trying to tell the court right now. Tyrone Blackburn is trying to tell the court that he did not realize he had made any mistakes on any of his filings until the month of June. That was last month. So all of the times that TD Jakes' attorneys was telling him, hey, whoa, with all of his filings, and they were telling him you're misquoting the law and you're misrepresentation and da-da-da-da-da. Nothing told Tyrone Blackburn to go back and to check his work. We learned that in grade school. You're supposed to check your work before you turn in your paper. Ain't that right, ladies and gentlemen? Come on, ladies and gentlemen. Aren't you supposed to check your work before you turn in your paper? Let me tell you something. When you work at the law firm, and Daryl can testify to this, and those of you that might have worked at a law firm, any of you that's in the chat ever worked in a law firm, put a 2 in the chat for me if you've ever worked at a law firm and as a paralegal or worked in any capacity in a firm. Y'all listen to me very carefully. When you get ready to turn in your paperwork, your caseload to the attorneys, because it goes from the case manager's case, it goes from the case analyst to the case manager, and then it goes to the attorney. That's how it works. Okay. Now you can call the case analyst, the paralegal, and then you can call the other managers paralegals if you want to, but it goes from paralegal, Steph, and you help me if I'm wrong, Steph, unless you all have a different process in your attorney's office. It goes from the case analyst, normally goes, and it depends on the words that they use. It may go to the paralegal. The paralegal is going to get all the documentation, all the evidence, they're going to review the case law. They're going to get all of that stuff. They're going to type that into the system. They're going to then turn over the file to the attorney. The attorney is then going to review all of the stuff in the case law and make sure everything is accurate, make sure it lines up, and that all of that stuff is proper. And then they take the file that they get from the case manager or the case analyst, and they take that to court. So if you're thinking the lawyers out there running and grabbing all of these documents, a lot of times it's not them. It is the paralegal or the case manager that has put all of this stuff together. Okay. And making sure that everything meets the legal precedent, et cetera, et cetera. Okay. But Tyrone Blackburn is trying to tell the court and to tell this judge, he did not recognize that he made a mistake until the month of June of 2025. That's why you're trying to tell the court. That's problematic. That is problematic. Irene, I cannot. I'm just saying. What is Steph saying? Let me see what Steph is saying. Come, let me pull up Steph. One thing I've learned is that no matter what work product I produce, it's the attorney's responsibility. That is correct. That is correct. That is absolutely correct. Because whatever you do, Steph, whatever you produce for the attorney, he then takes your file and he goes into court with your paperwork. So if your paperwork is inaccurate, you just cost the judge, you just cost the attorney a lot of time and effort and possibly sanctions. Just saying. Let us continue, ladies and gentlemen. The computer done made Tyrone Blackburn do all this. The computer. He didn't know he was making any mistakes until the month of June, which is which is amazing to me. Let us move on. As the deer panted for the water brook, let us continue to read. As the court will see from my attachments, I have completed the research and cited the misquoted content came from actual cases. They were just misattributed. I just cannot stand Tyrone Blackburn. So instead of admitting his mistake, well, he admitted his mistake. But in other words, what he's trying to say is, oh, it really did apply to the law. It just wasn't applied properly. Huh? Okay. All right, let's go. Then he goes into there. Rule 11 imposes requirements on attorneys and parties regarding pleadings and other court filings. First, a filing must not be presented for an improper purpose, such as to harass another party. Here we go. Second, the claims must be warranted by existing law or by a non-frivolous argument for extending or modifying existing law. Third, the factual contentions must have evidentiary support or be likely to have evidentiary support after discovery. Stop right there. Stop right there. Stop right there. I told Daryl, and I'm going to now tell you all this. Part of the reason why we're having all of this problem with Tyrone Blackburn, Duane Youngblood, co-conspirator number one, all of these false affidavits, because we did not have proper, in my opinion, evidentiary discovery. We did not have proper discovery. There was a reason why T.D. Jakes' attorneys moved for certain types of things at the beginning. But because of how all of this paperwork was submitted, it was submitted in such a way to confuse the court and confuse this whole system so that the system could not work properly. The only reason why Tyrone Blackburn did this stuff the way, in my opinion, he did it was to throw everything at the wall to confuse the system. And you're going to see that in just a moment, even more so. He said, finally, before filing, the parties and their attorneys must undertake an inquiry reasonable under the circumstances to verify compliance with Rule 11's requirements. If a party violates Rule 11, a court may impose an appropriate sanction on an attorney, law firm, or party that violated or is responsible for the violation. He cites the case law. In assessing Rule 11 compliance, courts in the Third Circuit apply an objective standard of reasonableness. What he's trying to say at this particular time, Judge, let's be reasonable here. Let's look at this from another reasonable place and viewpoint. The other courts apply a more broad and objective standard, a reasonableness, in order for them to make or to apply a sanction to an attorney. So not so fast, Judge. They don't normally go as harsh and as fast as you're going. Slow down there, Judge. You need to look at this from a more reasonable context in light of all of the things that I'm now sharing with you. That's in essence what he's trying to say. Let's move on, ladies and gentlemen. The legal standard to be applied when evaluating conduct allegedly violative of Rule 11 is reasonableness under the circumstances. This includes objective knowledge or belief at the time of the filing of the challenged paper that the claim is well grounded in law and in fact. Well, here I can stop right here, but Tyrone. If TD Jakes' attorneys filed responses to tell you that and challenge your filings and told you in their filings on more than one occasion that you were misrepresenting the case law and you kept doubling down on your misrepresentations, then it would be that one could reasonably assume that you are either doing it willfully as an attorney, or you're doing it well, in my opinion, you're just ignorant of the law, or you're willfully doing it to mischaracterize, to mischaracterize what the law actually states and what you're supposed to be submitting on behalf of your client. In my opinion, if it says here that you have to have an objective knowledge or belief at the time of your filing that the claim is well grounded, now listen, if it's not well grounded, if the other attorneys are coming to you telling you don't have a basis for what you're saying in the law. Is it just me? Am I making sense? Do y'all understand what I'm saying? Does that make sense to y'all? I'm just saying. I don't know. Maybe it's just me. I don't know. Beloved, I agree with you. Yes, I love the way you put that. He bought a bus ticket, but he was trying to ride a plane. I agree. Oh my God. Y'all don't realize. Oh my God. Okay. Let me keep going. I'm sorry. I'm going to enjoy this popcorn and eat this. Consideration of the amount of the time available to conduct the factual and legal investigation. You had plenty of time, Tyrone Blackburn. The necessity for reliance on the client for the underlying factual information and complexity of the legal factual issues implicated. So are you going to come back and say Duane Youngblood lied to you? Is that what you're trying to say? Okay, let's continue. Rule 11 does not require perfection. Sanctions are reserved for exceptional circumstances where a claim or motion is patently unmeritoriously or unmeritorious or frivolous. Okay, I had to sound that word out. Y'all forgive me. Satan done lied to him. That's what happened. As the Third Circuit explained, in this particular case, Wharton versus Superintendent, as officers of the court, lawyers must not mislead the court. So before they state facts, they must investigate reasonably. Are you saying, Tyrone, that you did not have enough time to investigate what your client was saying? Or are you saying, Tyrone, that you didn't have enough time to investigate what the law said, Tyrone Blackburn? Is that what you're trying to allude to? Just a question. I'm confused by this. He further affirms this duty by stating that the counsel must ensure that they make factual contentions, have evidentiary support, or if a specifically identified, will likely have evidentiary support after a reasonable opportunity for further investigation. So, Tyrone Blackburn, I'm going to stop right here. I'm going to highlight this point right here for you, Tyrone. What was your evidentiary support that you had for what your client was filing against TD Jakes? What evidentiary support did you have? This is the point where Alex Trebek would let the music play. Do 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 do. And this is the point when the Muppets would say, "Phenomena do do be do be do be do be do." This is when the Muppets would go, be do be do be do be do be do be do. Phenomena. You're crazy. You are. Look at what the statement says, you dim nut. Evidentiary support. Okay, I'm moving on. Where a Rule 11 violation is found, courts are encouraged to consider non-monetary sanctions, including formal reprimands or referrals to continuing legal education. So you know what he wants to do right here, Daryl. And what was my other person in here that I was Steph? Was it Steph D, the other legal of mine that was in here that put a 2 in here, Steph D, he wants to go to continuing ed. He say, I ain't smart enough. Please, Your Honor, don't hit me with no sanctions. You can hit me with a formal reprimand, or you can send me back to school. You can send me back to class. Steph D, this is, listen here, Steph D. I'm listen here. I am been laughing all morning. Oh, it's on its way. It's on its way. Train number 9. It's coming down Chicago line. Let me tell you. And I'm gonna tell y'all, I'm gonna give y'all 3 scenarios that's gonna happen here in a minute. Steph, let me tell you something. This is funny as heck, Steph. This is funny. He want to go to continuing ed, Steph. He want to go to continuing education, Steph. Daryl, he wants to go to continuing ed. Okay, let's move on. I'm just saying. Let's move on, ladies and gentlemen. The memorandum of law submitted in support of the motion to dismiss was a sincere and substantive attempt to challenge the legal sufficiency of the plaintiff's claim under established defamation and collusion precedent. The filing was not frivolous. It was rooted in binding federal and state case law. So now you're doubling down on your stupid stuff. Okay. All right. Here we go. The grave man of the motion to dismiss was the plaintiff, a public figure, initiated a defamation claim in federal court in response to public statements made by the defendant about his own lived experience and religious teachings. First of all, you can stop by own lived experiences because you're now saying that it actually happened. It has nothing to do with no damn religious teachings. Everything where you, all that Bible verses and Bible quoting, the court don't care about none of that. Like I done told you all, the only thing that they care about as far as God is concerned as it relates to court is the word God on the seal that the judge has behind his post behind there. The only time God enters the courtroom is on the seal. The rest of it, you can come in and swear and talk about, I swear to tell the whole truth. Everybody starts lying. God ain't got nothing to do with all of this. Let me just put that down there. So y'all need to get that out of your head. This has nothing to do with God. Matters that fall squarely within the protections of the First Amendment and Pennsylvania's public expression protections. These arguments were not manufactured, fabricated, or legally based. The legal theory advanced by the defendant, though now tainted by citation defects, was not ungrounded in fact or law. Every affirmative defense asserted in the motion was supported by authority I researched and reviewed in good faith. But Tyrone Blackburn, all your research and all of the stuff that you did in good faith was all wrong. That's why we're here and that's why we're talking about you. You keep hollering about good faith and you was doing everything in good faith. Now, ladies and gentlemen, this is like going to your teacher. After you done handed your math homework in, and your teacher looks up your paper and says to you, how did you arrive at this conclusion? Because you didn't show your work. You didn't show your work. How did you come to this lowest common denominator when you didn't show your work? So typically what your teacher will do is your teacher will give you back the paper, for those of you who had good teachers, and they will say, bring this back with showing me your actual work and how you arrived at this conclusion. So guess what's going to happen to Tyrone Blackburn? Steph D, you tell me if I'm wrong. And I need for some of y'all to come up. Steph D, you might want to come up here and talk to me in a minute too. I'm going to need you, the legal minds. I need the legal minds. You tell me if I'm thinking right, just based on my experience. At some point, if he wants to use this as his defense, the judge is going to have several questions for Tyrone Blackburn about, and one of those questions I told y'all earlier, if you're taking notes, at what point did you realize that you had effed up? Number 2, what did you do to rectify the fact that you had effed up? I'm going to go ahead and add this at number 3. At what point were you going to notify the court that you had effed up? Now, Tyrone Blackburn is trying to tell the judge that, well, by the time I realized I had made all of these mistakes, Duane Youngblood fired me, and I was just about to submit all the corrections to all the stuff that I had done wrong. That's what he said to the judge in his paper that I read to y'all. That's essentially what he said. Now, Steph D, at some point, will not Tyrone Blackburn have to show his access to these software programs and his printing out or his extraction from these Nexus, Lexus, and Westlake law to add to his court cases and to add to his papers that he was submitting? Won't he at some point have to show his work? Won't he have to show his work at some point if this is going to be his defense to the reason why he done messed up? Now, I don't know, Steph D. Let me, you answer this, because I don't know. I'm not a lawyer. I'm not even going to pretend that I'm going to be a lawyer. I'm just going to ask you. I'm asking questions here. Steph D, won't he have to show a chain of custody, or won't chain of custody or something come into effect where he's going to have to show when he arrived to this conclusion and how he got to this information? Because he's trying to convince the judge that he did it all in good faith. Everything I did, Judge, I did in good faith, Your Honor. And these were not ungrounded grounded in fact or law. They were just messed up. They were tainted. They were tainted by defects, by citation defects. Well, citations of the law, you're citating the law. So if you don't cite the law properly, you are misquoting the law. And that's what you're saying the judge should just allow to go through and not give you any sort of sanction? Steph D, I'm confused by this logic. I'm confused by the logic. Steph D, I think so too. Because he's going to have to show a chain of custody as far as when he came to this conclusion, and he's got to show when he printed this stuff out and added this to his responses. This is opening up a whole nother can of worms, which I think Tyrone Blackburn is designed to do. This is what he likes to do, ladies and gentlemen. This is what he want to do in the first place. Let's go on, y'all. Let's go on. He says, every affirmative defense asserted in the motion was supported by authority. I researched and reviewed in good faith. Now here's where he's going to get into problem. Oh my gosh, Sean Doe. I'm sorry to keep stopping, but this is what commentary is. This word right here is what's going to get him in trouble. He's now telling the judge he reviewed it. No, you didn't. No, you didn't. You can't tell the court you reviewed it and you submitted it to the court, but you reviewed all the documents. Now, if I had time, because I still have pages to read, I would tell you what happened to me when I went into court one time, because I got sued by somebody, and because people are stupid, and the person sued me. I'll tell you the story at the end of the live when y'all come up, when I drop the link. And y'all just remind me to tell y'all this whole reviewed crap, because this is gonna seal this right here. He said he reviewed it. That's gonna cause him a problem. Let's go on. The research I conducted before drafting the memorandum of law yielded over 50 authorities, including case law from federal and state courts. The research I conducted is time-stamped and began on May 5th. So here goes Daryl, you all, and what I said to you. He's going to have to show a chain of custody. He's saying he started his research in the month of May. And he reviewed it and downloaded those sources using his newly upgraded LexisNexis and Westlake law accounts. Although he later learned that the formatting and tagging mechanisms of these modernized legal research tool created quotation artifacts At no point was there any intent to deceive the court or fabricate authority. That's not going to work. This is not going to work because you had ample. Oh, man. Okay, let me move on. The legal foundation of the motion was sound. The formatting and attribution process was flawed. So he's saying the formatting and attribution process is what was flawed. The computer did it. We back to the computer did it again, y'all. Let's move on. I respectfully submit that the court's injury should focus not only on the surface level citation deficiencies, but also on whether the motion to dismiss, despite the editorial flaws, advanced a good faith argument grounded in fact and law. So now you want the court to go back and to reconsider because you finally corrected your homework and you're now trying to show the judge how you got and arrived to these conclusions. You out of your mind, Tyrone Blackburn. You're out of your mind, Tyrone Blackburn. You are out of your mind, Tyrone Blackburn. I'm going to keep reading because I know some of y'all ain't got, well, it's Saturday. Some of y'all might be at work. On June 17, 2025, I received a letter from the plaintiff's counsel identifying perceived violations of Rule 11 and invoking the 21-day safe harbor provision under Rule 11. That same week, I began a comprehensive review of the memorandum of law to remove or correct any problematic citations or formatting issues. Now, I want to pay close attention to something. He says he realized his mistake in May, but he didn't get the letter till June. Now, Steph D, he said he realized his mistake in May. He didn't get the letter till June. Steph D, then one can reasonably deduce if he recognized and realized that he made mistakes in the case law. It then became Tyrone Blackburn's responsibility to notify the court that he realized that he had misquoted the law, had misrepresentations and citations in the law, and that he planned on resubmitting the documents and the paperwork in which he had submitted. So between May, when he recognized that he made the mistake, and upon further review, May, and now all the way up until June, he's saying that that the same week he began a comprehensive review of the law to remove or correct any problematic quotations. But that's not what he said. If you go back here, he said, I researched and conducted its timestamp and began on May the 25th. That's what he said right here. Am I tripping? In the above paragraph, he said he researched and the research I conducted is timestamped and began in May. So then how do you get down to June? I'm just asking. And then on June 17th, because you get a letter, you say that same week you begin to do a comprehensive review of the memorandum of law to remove and correct any problematic quotations and citations. But you said on May the 5th, you begin to research and it's timestamp. You reviewed and downloaded those sources using your newly upgraded LexisNexis. So in May, you knew that you had mistakes made. So between May 5th and June the 17th, here's my question, Steph D. Did he send any notation to the court that he found his errors and the stuff that he did wrong? Did he notify the court that he planned on updating all of that stuff? Or he's using the excuse that he received a letter from the plaintiff's counsel? So TD Jakes' attorneys had to send him a letter to inform him that they were going to hit his behind with sanctions. When he says, according to this, he began researching it on May 5th and realized that he had a newly upgraded LexisNexis and accounts, and he later learned that he had formatting and tagging mechanisms that were incorrect and inaccurate. Don't play with me. I know how to read and I know how to comprehend. You do not get to say you didn't realize that, sir, all the way until June 25th, when you just stated here that you recognized this on May the 5th. Am I going crazy? Am I wrong, ladies and gentlemen? Y'all help me. because in a minute I'm about to get mad because I don't like Tyrone Blackburn. Tyrone plays too much. I don't like Tyrone Blackburn. I don't like Tyrone Blackburn. I don't like Tyrone Blackburn. Why is he trying to play in the judge's face and play in everybody's face? You said you recognized the fact on May 5th. You then said that you, after June 17th, when the council identified perceived violations, it's not a perceived violation. You just admitted that there were citations and things in the case law that you left out and that you did not include. And that you said that those errors you did not make on purpose, that the judge should be reasonable when he considers these citations that you so are well deserving of. I'm just saying. I don't understand. Okay, Irene, here we go. Because on June 10, 2025, ChatGPT released OpenAI 3 Pro mode. Hence the hush, Irene. Are you hearing what I'm saying to you, ladies and gentlemen? He playing in the court's face, and he playing in all of our faces. We're not even lawyers, and we can read this and be like, well, now, wait a minute, sir. How do you get from May to June? You realize your mistake in May, but now you're saying you didn't realize your mistake until June. And then you started looking at the law. Because you, in the previous paragraph, you said you realized it in May. Stephanie, I'm starting to feel the same way. Because he's throwing everything here but the kitchen sink. I'm going to keep reading, y'all, because I know y'all probably tired of me. But I just get so frustrated. Okay, let's go on. He said this process was not delayed or avoided. How was this? Okay, let me go back. On June 17, 2025, I received a letter from the plaintiff's counsel identifying perceived violations of Rule 11 and invoking the 21-day safe harbor provision under Rule 11. That same week, I began a comprehensive review of the memorandum of law to remove or correct any problematic quotations and citations or formatting issues. I planned to file an amended version that preserved the substance of the motion, but corrected any inadvertent quotation, misuses, or source misattributions. This process was not delayed or avoided. How was it not, Tyrone? How was it not? What are you talking about, sir? You said you recognized your mistake in May. You recognize your mistake in May. That's what you said. I'm just saying. Moving on. Unfortunately, before I can complete and file the corrected memorandum, I was involuntarily terminated as counsel via email by defendant Duane Youngblood at 10:28 p.m. on June 23rd. Now he's blaming Duane Youngblood. Now he's trying to throw Duane Youngblood under the bus. It's my client's fault. The computer had trouble, and now it's my client's fault. Duane fired me. That's why I couldn't submit the right paperwork, Your Honor. Wait a minute, Daryl. Come on, Daryl. Come on back, Daryl. Daryl, Steph D, he fired me. That's why I couldn't get the paperwork in to submit all the mistakes that I had made. Oh, Your Honor, please. Oh, please, Your Honor. I should have had some wine for this. He said, listen here, ladies and gentlemen, read what it said. The very next day, on June 24th, I received an email from the defendant's local counsel directing me to sign and return a pre-drafted notice of withdrawal. And I was given no opportunity to discuss the Rule 11 issues with the client or local counsel, nor was I given a chance to explain the corrective work that was already in progress. You a lie, nigga. You a lie, nigga. You are a lie, nigga. And that's my opinion. You a lie, nigga. What do you do when you've done all you can and your lawyer screws up all the time? Well, you just stand When there's nothing left to do, you just stand and watch the judge bring you through. After you've done all you can, you just stand. Y'all listen to me. What I'm trying to tell you right now, this is that bull. This is that F around and find out. He done lied and said it was the computer. He done lied and said it was Duane Youngblood. Now he's saying, Your Honor, before I could even file any corrections or anything, the man fired me. I was fired. I was fired. He said I was given no opportunity to discuss the Rule 11 issues with the client or local counsel. Well, hold on. Hold on then, you all. I'm gonna throw something else at you. This is gonna cause all kind of problems. Now, Daryl, Steph D, y'all listen up. What Tyrone Blackburn is now claiming is that he was boxed out from his own client. His own client boxed him out, and he was not able to have any communication when he is the attorney of record on file. I'm just saying. He was representing Duane Youngblood, pro hoc vice or vice, however you make that statement, and he was operating using the pro hoc stance because his license is in New York, but he was operating under the pro hoc vice situation. The attorney or the law firm that gave him the ability to operate pro hoc vice. Now, all y'all legal folks in here, y'all help me out. They gave him the ability to operate in the state of Pennsylvania through their license. So here's the thing. So are you now saying to the judge and to the court, Tyrone Blackburn, that the other attorneys and attorney office did not give you access to your client? So you didn't have access to the client because you were just using their license to give you the ability to work in the state of Pennsylvania. So now what you have just said in this statement, sir, you said you were boxed out and terminated. That's what you just said. That's what you just said. He said he was given no opportunity to discuss the rule issues with the client or with the local counsel. So he's saying that the attorney's office, where he held his pro hoc vice license, them folks didn't even talk to him and tell him anything and give him an opportunity to explain his mistakes or correct his behavior. So let me ask you another thing. Tyrone. I'm not a lawyer. Let me ask this. So are you trying to say, Tyrone Blackburn, that this law firm where you brought the client through the pro hoc vice situation spoke to your client without your knowledge and without your understanding, being present with this client, they completely X'd you out of the situation? Listen here, Steph D. That is also problematic. That is problematic. From a legal standpoint, that's problematic. And that also brings in another set of legal implications, ladies and gentlemen. I shall go on because I want to see how the judge handles this. Okay, let's move on. He says, I was given no opportunity to discuss it, nor was I given a chance to explain that corrective work was already in progress. My withdrawal was not strategic. What that little white boy say on that TikTok? Bullshit. Bullshit. Tyrone Blackburn, you ought to stop it. There's no reason for you to say this unless because you know that it was. But anyway, I'm going to move on. What'd you say, Mary? Something tells me he ignored them or told them to pound sand when they tried to ask him what the F is going on. I agree with you, Mary, because he's good at telling people to pound the sand, isn't he? He's good at that. Let us continue, ladies and gentlemen. He said it was not a way to avoid responsibility. It was a coincidence of a client relationship that had come to a sudden and unexpected end. I had every intention of remaining in the case and completing the corrective process. That fact that I was unable to do so was beyond my control. Now, Steph D, I don't know a lot about the law. I don't know a lot about the law. But can your client fire you in the middle of the court case without the judge's approval? Can that happen? Can they just say, I don't want you to represent me anymore? Can they do that? Because the attorney on file, as far as representation, as far as I was concerned, I could swear was Tyrone Blackburn. These white folks just showed up because their license is also in jeopardy because they had to make some filings for Duane Youngblood. But as the attorney that I understood was Tyrone Blackburn. Now, Steph D, am I tripping? Am I wrong? Am I missing it? I didn't have a chance to call my attorney friend before I went live today, so I'm gonna call them when I get off of here because there's some strychnine in this here corn. I'm just trying to tell y'all. And Tyrone Blackburn has poisoned this entire process. So no matter what fruit that you pull from this tree, it is all poisonous. Well, see, Courtney, that also opens up another can of worms. That's why I'm trying to tell you. Because according to the Tyrone Blackburn, he was working pro bono. Now, Courtney, can I tell y'all something here? This is one of the reasons why this newest attorney, in his filing, his whole thing was, I can neither confirm nor deny. Okay. Now, Irene, if that is the case, then there must be paperwork filed, and that paperwork must be signed in order for you to say that this person is no longer your attorney, and that you assign this new attorney on this new specific day, right? There has to be a chain of custody here, you all. You cannot, oh, he's no longer my attorney. This person's now my attorney. And according to Tyrone Blackburn, he didn't even know that the man had fired him. And he didn't even have a chance to talk to the man, according to Tyrone Blackburn. Irene, that's what he said. Irene, that's what the man said. Don't make me go back and read it, because that's what he said, y'all. I'm just saying. Lord have mercy. Let's see here. Okay. All right. Well, that's a good answer. That's a good answer. Oh my God. Tyrone Blackburn did this on purpose. I don't care what y'all say. It was strategic. It was a coincidence, he claims. The fact that I was unable to do so, he's saying, was beyond his control. Bullshit. Moving right along. The citation and quotation errors identified by the plaintiff's counsel and flagged in the court's order to show cause arose in part from my recent adoption of upgraded legal research platforms, Legal Nexus Protege and West Next Co-Counsel. These tools were marketed to me as solutions for my solo practitioners who manage high caseloads without the court support of staff. So now he done blamed the computer. He done blame Duane Youngblood. So now he's blaming the fact that he don't have no staff. So for all of you wondering if he got a staff, he's trying to tell you he has high caseloads, but he ain't got no staff. He ain't got no staff. That's what he's trying to tell you. He said they promised to streamline research, expedite drafting, and offer integrated support for site checking and case analysis. Admittedly, I was excited to have access to new technology that could reduce the time required for legal research and writing by nearly half. 60% of my work is pro bono. And at times, I did not have enough hours in the day to complete all the tasks required of me. He done blame the computer. He done blame Duane Youngblood. He done blame the fact that he don't have no staff. And now he trying to blame God because he don't have enough time in the day to do his work. Now it's God's fault. I keep running out of time, Lord. I don't have enough hours in the day. That's what he said. I don't have enough hours in the day. Now it's God's fault. I done ran out of time. I need to be like Joshua when he was fighting the Midianites. I need to be able to tell the sun to stand still while I complete all of my work. This is ridiculous. This is ridiculous. I'm just saying. Okay, let me move on. It is difficult to find a co-counsel to assist with the work I do because, quite frankly, no one wants to work for free. No, Duane Youngblood, no, Tyrone Blackburn. No one wants to work bullshit ass cases and cases where you misquote the law and you do not adhere to the principles of the law and citate and litigate these things properly. Okay. No, it's difficult. There are many attorneys that will take on legitimate cases and do those cases for free when there is a case. But I'm going to tell you, ladies and gentlemen, just based on what I have seen and what we have heard and what we have followed since November of last year, this is some horrible legal work on behalf of Tyrone Blackburn. And now he's blaming God because he don't have enough time in the day to do all the work that he needs to do. Well, maybe you should stop ambulance chasing and going after high profile cases and submitting $6 million requests to individuals or telling them you're going to file court cases against them and them smacking you with lawsuits so you would not have this problem. Guess what, sir? This isn't going to work. Moving right along. My firm routinely handles civil rights, employment, sexual assault, and medical malpractice matters for clients who are indigent, unemployed, or recovering from a debilitating trauma. In the case at hand, I provided the defendant with pro bono legal services for nearly 9 months. Steph, I can't go through everything because that's problematic too. But I know what you're saying, Steph. But I totally get what you're saying. But let's move on because he's working pro hoc vice, if you understand. But let's move on. He says he provided the defendant with pro bono legal services for 9 months. Now, ladies and gentlemen, this is also problematic, this statement right here, because did he not tell the judge in one of his filings that he needed to be reimbursed for the work that he was doing? He did tell the judge that. Y'all do remember that, right? Y'all remember he told the judge that. And Keisha, Daryl, and me was hollering about this a minute ago before I got live because that's exactly what Daryl said. Daryl said, Marcellus, you should pull up Flip Wilson and say the devil made me do it. We were laughing so hard about that. Listen here. He's now saying again, he's doubling down that he did everything pro bono, but in the legal filings that he made, he said he needed to be reimbursed for his services. Yes, absolutely. Absolutely. Ding, 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 ding. Ding, 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 ding. Moving right along. Okay, although I utilize the citation review features included with the upgraded platforms, I now understand that I initially misrepresented how those tools handle paraphrased text and inserted quotation marks. I failed to independently confirm that the quotation formatting matched the underlining source material in every instance. Now, ladies and gentlemen, did he not tell us several paragraphs ago that he reviewed his work? He said he reviewed the work. I feel like beating on my chest like I'm in the damn Amazon. He said he reviewed his work. Moving right on. That failure was mine alone. But it was a technological and editorial error, not an act of deception or an attempt to defraud the court. Bullshit. 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 That's my opinion. Bullshit. Bullshit. I did not. I did my due diligence to the best of my understanding. I read the document thoroughly before filing it, ran the citation review feature, and cross-checked the sources. Still, mistakes remain. I deeply regret the error survived by my review. So you again admit that you reviewed the stuff. So now comes into play, Steph D, Daryl, and all of you that are listening. Now comes into play that you are a horrible attorney. You're just a horrible attorney. Moving right along. He said that he was still learning to use. Well, sir, if you were using this, still learning to use it, maybe you should not have used it, and you should have went to the law books and did it old fashioned and not tried to use technology that you didn't know how to use. So now you're just going to tell the judge, oh, judge, don't hit me with sanctions because I used a new computer. Judge, I had a new program. I had a new program. I wouldn't be trusting ChatGPT or Shepard. You got that right. What's the mind to Marcellus? I don't know what you mean by that, Sharon. I'm sorry. I'm having a senior moment. I don't know what you mean by that. Listen here, big time. I'm just reading this for the fun of it because this is ridiculous. Let's go on, ladies and gentlemen. The court's order to show cause specifically questioned the accuracy of several quotations, including attributions from Castellani versus Scranton Times, and other Pennsylvania cases. I take full responsibility for each of the challenge quotations and acknowledge that some were imprecise paraphrases, mistakenly enclosed in quotation marks, while others were misattributed due to errors during drafting and formatting. Your Honor, I just put the parentheses in the wrong place. Let me move on. At the time, I understood that all I had to do was highlight the section of the cases and authorities I researched and wanted to use, upload those cases and authorities, as well as supporting materials, complaint, court orders, and opinions, and any relevant transcripts that were written. Instruction and upgraded legal research platforms would extract the information and listen. At the end of this, look what he says. I was wrong. Y'all listen to me. I'm not even an attorney. What did I just say? He should have did it the old-fashioned way. He should have did his research and uploaded that information into the system. And he just said right here that that's exactly what he should have done. And then let the computer push out for him based upon the old-fashioned way of doing the research, which means you got to go to the book and you got to pull up the case law, right? Or you got to go research all of the case law and look at all of the case law. You was wrong, sir. And I'm glad you said this. So these statements right here is what's going to seal the deal, Steph D. I was wrong. What was the other one he made? Several things that he does. Oh, I reviewed. Some of them statements right there are what's gonna seal the nail in the coffin for him. I don't think he do own any books. Everything is Chat GPT. Or he's waiting on his law books to come from the Home Shopping Network. They haven't been delivered yet. Steph D, his books ain't arrived yet. Y'all remember when we was in school, they had the book club and they get you to sign them little papers every now and then, like every quarter as a fundraiser, and you get that little thin piece of paper and you get to say how many books you wanted. He waiting on that. He ain't got that yet. It's crazy. Then he goes through all of this and then he give you this. He said, now I understand that the paraphrases, particularly those closely tackling the language from cases, must never be enclosed in quotations unless they accurately reflect the precise language of the cited source. You a damn attorney and you didn't know this? I didn't go to law school, but didn't they teach you that in law school? You supposed to learn that in law school. You now acting like you know what he doing? He acting like this is on the job training. Listen here, I am Courtney. He acting like this is an on the job training. I told y'all to get y'all popcorn and get you something to drink. Now listen. He said, while the original intention was to streamline legal standards in a reader-friendly format, I now understand paraphrases, particularly those closely tracking the language from cases, must never be enclosed and must reflect the precise language of the source. In this instance, I failed to meet that standard. All of these statements, I failed, I was wrong, I reviewed, they was going to nail his coffin. However, the underlying authorities that support the legal proposition were real cases I reviewed, highlighted during my research, and accurately reflect the substantive requirements for civil conspiracy under the Pennsylvania law. Well, the judge already told you that wasn't going down. None of these paraphrases were invented or drawn from fictitious cases. Instead, the problem lay in the way that they were formatted and attributed. No, Tyrone, no. Instead, the problem lie in the way that you formatted, but also the way that you argued in your responses, sir. The case law is to help you formulate your argument in order to prove your case. Steph D, I'm Daryl. I'm not an attorney, but the last time I checked, the law is there for you, and the case law is there for you in order to help you formulate your argument for your case. The problem is, sir, not only was your case, the way you formatted your case is wrong, but the way you argued though that information was also improper. Now, I'm going to pass the offering bucket in a minute because I'm doing some work here. He's out of his mind. And listen here, I done ran out of mine too. I'm down. You see, I'm savoring a little bit, Alice. I need another one. Y'all understand it's 910 pages. Let me hurry up. What we at? An hour and 30 minutes. Here we go. I'm going to try to get the rest. I'm going to just read through the rest of this with no commentary. And then so when we hit the roughly get close to the 2-hour mark, we'll be done. All right, here we go. I'm not going to stop anymore. From now on, this is some bullshit. From now on, I understand that this level of precision must be maintained even in a time constraint or high volume litigation setting. I fully acknowledge that from the court's vantage point, the circumstances surrounding the filing of the motions to dismiss and my subsequent withdrawal as counsel may appear to reflect an intent to deflect responsibility for filing that contains significant citation errors. The absence of my immediate corrections or clarifications followed by my departure from the case creates an unsustainable and compelling inference of bad faith. The court is justified in viewing the sequence of events as problematic and as potentially evidencing a deliberate attempt to escape liability. But everything is not what it seems. Okay. Lord, I could take some time. I could preach right there, but let's move on. As previously stated, upon reviewing Rule 11 Safe Harbor letter from plaintiff's counsel, I immediately began the process of correcting the record consistent with my obligations under Rule 11. My plan was straightforward to remove all quotation marks around paraphrase or imprecise citations, correct misattributions, and ensure that every statement of the law or fact was sourced correctly. I had no intention whatsoever of abandoning the filing or to evade the correction process. To the contrary, I took the allegation seriously and had already begun implementing the changes. I did not seek to withdraw. I was involuntarily. True or false? False. I'll go ahead and answer for you. False. I was involuntarily terminated by my client and instructed by counsel to file a withdrawal prepared by them without any discussion about the pending Rule 11 issues or correction process I had undertaken. I had been given even a few more days. I would have filed the corrective memorandum. I gained nothing by misleading the court. This case was never about evasion or deception. I've always acted in earnest, and my singular goal has been to help the defendant. What I believe and what I still believe is his constitutionally protected right to speak about his lived experiences. From October through June of 2023, I dedicated myself to the case. I spoke with the witnesses, conducted extensive what witnesses? Conducted extensive research, drafted motions, and responded to numerous filings, all without compensation and assistance from a paralegal or an associate. So he's saying, I ain't had no help, Judge. Judge, help me. You got to call that number. Call that number. Say, I'm going to help you, Tyrone. I'm going to help you. Wait a minute, Moni Lynn. Call them numbers. Call them numbers. Call them numbers on the screen and say, I'm going to help you, Tyrone. I'm going to help you. What happened? What? Satan done lied to you. Yes, Satan. Satan done lied to you. Oh, Lord, help me. I'm so sorry, y'all. Okay. Oh, Lord. Satan done lied to this boy. The anti-SLAPP motion I filed early in this case did not contain similar issues for attribution. The motion reflected the same commitment to accuracy advocacy that I brought to the motion to dismiss, but without the complications introduced by newly adopted technology. My God from Zion. I hope y'all understand what he's saying right here, but I'm gonna keep moving. At the time I was removed, I had every intention of remaining in the case and continuing to represent the defendant for free. My commitment to this matter was never driven by financial gain. Bullshit. Right? The bull. It was rooted in genuine belief that the lawsuit was an impermissible attempt to chill the defendant's First Amendment rights. My work was focused entirely on helping the defendant fight what I understood to be a defamation claim brought in bad faith for the purpose of silencing his public account of lived experiences. The court's concerns are serious and warranted. This is also going to cause him problems, because you're admitting right here that it's warranted, sir. But I ask only that they be evaluated with the full context in mind. I did not abandon my ethical responsibilities to correct these errors. I was deprived of the opportunity to fulfill them. This right here is a lie to me. It is a lie to me, sir. This is a lie to me. It is a lie to me based upon your own dates. In conclusion, ladies and gentlemen, he respectfully submits this memorandum not to excuse or minimize the citation errors that appeared in the motion to dismiss memorandum of law, but to candidly explain the circumstances surrounding. The computer made me do it. Duane Youngblood fired me. I have no staff, and God didn't give me enough time. Those are your 4 reasons right there. In May, well, remember, he said in May that he realized he had made the mistakes on May the 5th, Steph. He said he realized he made the mistakes way back on May the 5th. That's what he said. Them is the 4 reasons why he gave, y'all. Give him the 4 reasons. Daryl, he don't have a living room law firm. He got a Starbucks law firm. He getting all his information. He using the free Wi-Fi and the chat GPT. Well, that is correct, Steph. And that's why it's not going to work. Steph, that's why it's not going to work. That's not why it's not going to work. The judge going to eat him alive. All right, moving right along. Unless the judge decides to have mercy on him. And I don't see no mercy coming for this mess. I really don't. Because this is too much. I'm just saying, and all of y'all are correct. That's a whole mess. This is a whole mess. Okay. The filing at issue was never intended to mislead, The substance of the motion was grounded in legal authority, which I researched, downloaded, and reviewed. The citation and quotation issues were not the result of fraud or deception, still rather than an unintended byproduct of transitioning to modernized legal research tools, specifically marketed to solo practitioners like me who lack staff, paralegals, or associates to rely on. I understood the output of these tools and failed to catch formatting and attribution errors, and for that I will accept full responsibility. Oh, you gonna accept it, all right? Because you full of shit. Oh, I'm sorry. I'm sorry. I need to stop cursing so much. Let me stop. I just forget I even said that. I'm so sorry, y'all. I apologize. I attempted to take immediate steps to correct the record of receiving the 21-day letter from opposing counsel. Well, you said, Tyrone, in the earlier statement that you realized your mistake on May the 5th. I intended to file a corrected memorandum that preserved the substance of the motion while addressing the citation concerns, just as Rule 11 contemplates. However, I was involuntarily terminated by my client before I could complete that process. I did not choose to abandon the case or to avoid correcting the record. I was denied the opportunity to do so. I understand the seriousness of the court's concern, and I fully appreciate why the optics of withdrawal without correction could raise questions. But I assure the court that my actions were not driven by malice, evasion, or disrespect, but were the result of a confluence of events. My goal now is to demonstrate that I was engaged in good faith throughout, that I was actively trying to correct the filing, and that I remain committed to the standards of candor and responsibility by Rule 11. So this right here says that, Your Honor, that even though I broke all the rules and I didn't adhere to the legal standards, I want to let you know that I am doing this in good faith now, and that I'm committed to good standards and good candor of responsibility, and want to uphold what the court deems necessary in order to practice. I respectfully request that this court consider the totality of the circumstances when deliberating on whether to impose sanctions. That's his statement. Now, here's the certificate of service, ladies and gentlemen. Here's his affidavit under the penalty of perjury. He takes this matter extremely seriously. He's practiced law since 2018, and during that time, he has never encountered a citation or quotation issues in any legal filing or court submitted to a court. That's what he's saying. This is the first instance of any of this into his professional career, is what he's claiming. Which can't be true, because if we Google this, didn't they say that he had some situations? If you Google it, they said that in the state of New York, he was going through something. I don't know specifically what that was, but I know that he had some type of issue in the state of New York. I don't know what the specifics were to that. I have always respected the Rule of 11, blah, blah, blah. Upon receipt of Rule 11 safe harbor letter, I immediately began reviewing and revising the memorandum of law in question. I removed the quotation marks, blah, blah, blah. So I went back, Your Honor, so I could show you my work, blah, 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 blah. However, before I could finish, my client got rid of me. These are all the excuses he's using, okay? The citation issues were not a result of bad faith or intent to mislead the court. Instead, it was the computer. The computer did it. Here go the excuses again. The computer did it. That's why I ain't reading through all this. Unwisely, I unquestionably trusted the accuracy of these platforms. So much so, I was a LexisNexis representative in school. Listen to me carefully. This is also going to come into play. So you represented this software and this company, and you didn't know that this company had issues, and they did not list out the full quotations of the case law, that you had to go back and double check your work. You didn't know that as a representative of the software. You didn't know that, Tyrone? Did y'all see what he said right here? He said he was a LexisNexis representative in law school. Moving right along. One of the issues raised in the court's order to show cause of citation to quote, I'm just saying, memorandum of opinion denying the anti-SLAPP motion. I acknowledge that motion to dismiss was inadvertently quoted and paraphrased language from an opinion that, though it were verbatim quote, this error resulted in my misuse of the upgraded legal research tool, which permitted users to upload source material and automatically generate text for integration. The computer made me do it. The reason why I lost the anti-slap motion is what he's saying is because the computer made me do it. The reason why we didn't win our anti-slap motion, the computer made me do it. At no time was there any intent to deceive or mislead. The prior anti-slap motion, which was manually drafted and filed without the use of upgraded version of the legal research tool, contained no such errors. I respectfully ask the court to view that misquotation not as a product of bad faith, but as an unintended consequence of integrating unfamiliar tools. How in one breath that you say you don't have no errors, but then you're going to come down and ask the court to view it, view that and consider that. That makes no sense whatsoever to me. But moving right along, I'm just saying, you all, I already corrected and removed several citations, blah, 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 within the 21-day period and window. I have since conducted a thorough audit of all active cases filings generated using these upgraded subscriptions and have begun correcting any citation or formatting errors. In addition to this audit, I have completed continuing legal education courses to better understand. Your honor, please don't hit me with no citations, because I done went to continuing ed. Your honor, I done put myself back in school because obviously I made some mistakes, your honor, and I done went back to class. I done bought you back my paper to show you my work, your honor. I was gonna show you my work, your honor, but before I could show you my work, your honor, Duane Youngblood fired me. And when he fired me, your honor, I couldn't show you my work. I was in the process of showing you how I was trying to solve this problem, improve this case, your honor. But your honor, he fired me before I could show my work, your honor. And so, your honor, please understand, your honor, that I went back to school to better myself. I'm throwing myself on the mercy of the court because I went back to school, your honor, and got some continuing education, your honor, so I could better understand how I'm supposed to use all of this stuff, your honor. I didn't even know how I'm supposed to use all of this stuff, your honor. Your honor, please understand and use all of this in your estimation and understanding before you hit me with these here sections, your honor, please. That's what that is. That's what that is right there. All that what I just did right there, that's what that is right there. That's what that was right there. All of that right there, that's what that was. Listen here. Number one, it says, understanding the implications of art. Look at what it said. This is what's going to seal the deal. Look what he types in here. Number one, ABA, AI is changing the legal profession, but not your ethical duty. What you say, Tyrone Blackburn, what you list right here? AI is changing the legal profession, but not your ethical duty. So you're admitting right here that you did not uphold the standards of your ethical duty. So why then should you not be hit with sanctions? Oh, your honor, because I was trusting the system. I was trusting LexisNexis and the other program, your honor. Oh, your honor. And I had to go back to school to realize that I had a professional responsibility and an ethical duty to uphold and make sure that I reviewed all the documents, your honor. Please, your honor, please. That's what he's saying. You have to catch up to AI ethically. How the existing ethics rule apply to artificial intelligence, how to guide our lawyers in avoiding the ethical pitfalls. Well, you're in an ethical pitfall, sir. You ain't even in a pitfall. You in a whole cave. You ain't in a pit. You in a cave that don't have no bottom, because you are a bottomless bottom feeder. And I said it. Listen what he says, y'all. I have also registered for additional CLEs addressing AI ethics. Is he trying to say continuing education right here, CLEs? And legal research accuracy, the best practice for solo practitioners, your honor. Your honor, I'm by myself, your honor, and I'm doing the best I can, your honor. I can't keep up, your honor. I was using this AI program, and the program It's got me in here, Your Honor, and about to be sanctioned by you, and I need you to have some faith in me, Your Honor, please. I done went back to school, Your Honor, please. You know how the kids, after you done spanked them a little bit and they know they're in trouble, you know how they start breathing off. This him breathing off. Okay. I need to go into my private life so I can talk how I want to talk. I respectfully refer the court to my prior affidavit in support of the defendant's motion to dismiss, which provides more details. That filing and motion itself were supported by over 50 legal authorities that I reviewed. Look, here we go. Irene and Steph D. Y'all asked about May 5th. What happened in May 5th? He said he reviewed this stuff in May. Did he file anything with the court between May and June before his client fired him? Did he go to his client and tell his client that he had made a mistake, or he realized that he had made a mistake between after May 5th? Did he tell his client that? No. I'm just saying. Tyrone Blackburn, I'm sorry. You're a fool. You, in my opinion, you're a whole dummy. He said the citation and quotations were never intentional. I understand the optics of how it looks, Your Honor, but I did not withdraw voluntarily. But you tried to withdraw from the case. You tried. Okay, so you all, let me look at something real quick. Let me pull something over. Let me pull something over. Because y'all know I'm not new to it. I'm true to it. Let's do some research here. All right, let's go down here. This is the beginning of the complaint. Let's find the date when he actually asked to be removed from the case. Let's find that date. Briefing, order. I'm gonna say, ladies and gentlemen, I might be incorrect. Okay. So he's saying that on June the 25th is when he filed for his motion to be removed as the attorney. But I could have sworn before June he asked to be removed off of this case. I'm going to go back and look again. But there is another situation where, because this wasn't the first time that he asked to be removed from this case, but we'll come back. We'll revisit that. In a minute. We'll revisit that. I don't want to waste you guys' time. I requested the court consider my clean record, the significant steps that I have taken to rectify my actions. What clean steps the significant steps? What step? You didn't try to correct this until these people sent you a whole letter. Oh, I'm too through with this bull. Okay. Let me just quickly go through all of this. Now, ladies and gentlemen, everything that you will see, the next 71 pages that he submitted to the court, are exhibits to try and prove his case. This is the letter that TD Jakes' attorneys sent to him, telling him that he had screwed up, and they sent him this on June the 17th. Now let's have an adult conversation here for just a minute. Let me drop the link. I'm gonna go ahead and drop the link for anybody that wants to come up to, because at this point, all I'm gonna be doing is showing you pictures. This is show and tell at this point. This is show and tell. Show and tell. Mary, Steph D, anybody that wants to come up. I want to talk to the legal minds first, because I know y'all did this type of work. So, but Steph D, y'all hit the darn button. And when I can get over here, I want to talk to y'all as adults, as matriculating adults. I want to talk to y'all as some people who use your brain. More, can you hear me?
Yep.
Mary, can you hear me?
Yes, can you hear me?
I can't hear you now. I do realize, ladies and gentlemen, they're not on the screen, but y'all can hear them. I'm gonna put you guys up on the screen in just a minute, but uh, let me pin this link. But I want to have this. I want to have this conversation because see, dates and things like this trigger me and they matter to me. And y'all, if y'all know how I work, I am meticulous. I know how to go and connect some dots. So let me share some things with you. I was known for that, by the way, at the Church Folk Revolution. He's saying on June 17th, when they drafted this letter, when they sent him this letter, he was unaware of his violations of all of this Rule 11. Daryl,
Mm-hmm.
the previous filings that TD Jakes' attorneys had filed, they told him in those filings that he was wrong and that he had misquoted the law and that the law was incorrect. And Tyrone Blackburn kept responding by telling them to kick rocks. They didn't know what they were talking about, and they was misrepresenting what he said. Am I right or am I wrong?
You're correct.
You're right.
Okay. June 17th, y'all keep this in mind. He's saying he did not know that he was doing this until June 17th. But if you take a look at all of these filings that have been made in this case, TD Jakes' attorneys have been filing after filing after filing, telling Tyrone Blackburn that he was misrepresenting the law and he was leaving out whole parts of the case law. They clearly communicated that to him. Oh, I'm sorry. Several times. So him saying that he did not know that he was misrepresenting the law is not going to work in this case, you all, because he is lying. He's been told filing after filing after filing. He did nothing to rectify the situation, even when the other attorneys cited the case law, showed him where he made his errors, right? Because they showed him in their responses where he made his errors. He's trying to convince the judge and to convince the court he did not realize he was making no mistakes, y'all, until June the 17th.
Mm-hmm.
But even in this same filing, Daryl, he said on May the 5th, he recognized he had made some mistakes and he began doing his research and correcting his mistakes way back in May.
So I was just, so I had a couple of timeline questions and all of that. I feel like, so in overall, I feel like I'll use a football analogy where it's like one and goal and defense keeps false starting and false starting. So we can never get the play to count. We
Correct.
can't move forward with the game.
Right.
And to what you just said, the judge gave you the teacher's key to the test and you still failed the test.
Correct.
They did the hard work for you by telling you what you did wrong to go correct it. But what I'm trying to figure out, do we remember the exact, or I don't know if we know the exact date or the roundabout month that Youngblood was released?
I got to go back and look in that document, but about a month after Youngblood was released is when I believe he was on Larry's platform. He hadn't been out of jail a full month.
Okay, because if I'm not mistaken, I don't know what page it was, maybe page 8 or 9 or maybe 10. Did he say that he had been on this case for 9 months?
That is what he said.
Because 9 months takes it back to October if we count today. If we go today and go back 9 months, that takes us to October. So does that mean that he was in on some of these jail calls? Did he know about, but even on top of that, the attorney who filed the Pro Hoc attorney, when he filed all of this, he said Duane had no knowledge of this, but Tyrone said 9 months.
Correct.
Duane would have had knowledge of everything. So is he gonna? So like if they were to hear this, are they gonna say the 9 months was a oopsie? Oh, it was another computer error.
But everything with this is an oopsie. I mean, he keeps moving the goalposts, and this is why he's going to get hit with sanctions, is because he's playing with the court. You know what I'm saying? He's playing in the face of the court. We say he's playing in the face of the court, but he's not getting these dates down at all, and he's not adhering to even the things that he said, because he said he realized his mistakes in the month of May. Between May and June, he filed nothing with the court to tell the court that he had made these mistakes, and that he was going to correct these mistakes. So are you trying to tell this court, Tyrone Blackburn, that you and your client had no communication this entire time, going back and forth with all of these filings? You had no communications with your client until the time that he decided to fire you. Is that what you're going to tell the court?
He's gonna
Right.
have
And
to
I mean,
explain that.
that part, because
Yeah.
literally okay, so in terms of switching legal representation, there is protocol to it. You can change whenever you would like to, but usually what happens, and I know Tyrone said he did it for free, whichever attorney that you're dropping, they will send a letter in saying, I'm no longer, representing this person, but I wish to impose any liens for the work that I have done
That's
on
right.
this case out
Hmm.
of the settlement. But, obviously he said he did it pro bono. Lies.
Right.
Um, and then software updates is not an excuse, because I remember I was working a case and they had included medical records for the complete wrong client. And when I brought it back to the attorney hadn't checked the paralegal's work. I bet you that paralegal was no longer working in that office. And that
Right.
was because of a software update.
Yeah.
And I guess like some documents got renamed or whatever. It does, the court doesn't care. A lot of these sites and stuff will tell you, they'll tell you months in advance, we are updating our database. They tell you in advance. So that's your heads up right there to proofread, check your work, all the stuff he did not do because it was ChatGPT who did it.
Mm-hmm.
But yeah, it's a lot with the timelines not adding up. The Pennsylvania people stuff is directly contradicting the whole 9 months thing, because obviously Youngblood and Tyrone were in communication prior to this. But I had some other stuff, but I'll let some of y'all go ahead and talk.
Okay, before y'all talk, I want to read to y'all this line right here. Let me read to you this line right here. Where is it? Do you all know that he quoted Jones versus P. Diddy Combs in this situation? If
Mm.
you go down here to on page 20, he actually quoted the P. Diddy Combs case.
Yes,
Moreover,
you did.
the
There it is.
counsel for the defendant has recently been admonished by another federal judge. So he's telling the judge that he has been admonished for making misrepresentations of the law. But didn't he just say in another previous paragraph that he's never been admonished or been addressed by another court or for any misrepresentation?
Yes, he
Didn't he
did.
just
Mm-hmm.
say that?
He sure
Yes, he
did.
did.
Mm-hmm.
Okay, I'm just saying. I'm
Yep.
just saying. Now, if you all can see what he's trying to do, he's trying to say things and then throw it in at the end and say, "Oh yeah, but this happened to me. This
Hmm.
happened to me."
Hmm. Yep, that darn computer just did it to me.
All right, welcome Steph D, everybody to the
Hi.
platform.
This is the first time I've ever done this, so I'm a little shy.
It's
So,
okay. It's okay. Just tell us what your thoughts are.
well, you
Um,
know, I've been working in the field of law with attorneys for 37 years,
oh
and
wow.
I've seen attorneys get themselves into this kind of trouble. I've never actually worked for one that did, but I've seen attorneys get themselves into this kind of trouble, and they ended up with serious sanctions. You can't blame a computer or AI or any of that nonsense for your failure to do proper research, which is why I asked, well, doesn't he have books? Because, like I said, I'm old fashioned. I'll look something up on the computer, but then I go and I look it up in the book. And I just can't even imagine trusting AI to shepherdize a case. That just boggles my mind. And to blame everything, and I keep going back to that May 5th date. I worked for a litigation attorney, and one of the things he drilled into my head was, if there's an error made, I have to fix it as soon as I am aware of the error.
Mm-hmm.
You can't wait 2 months and then say, "Oh, I just got told about this because I got a letter from the defendants."
Yeah, but
Child, he was having tacos and tequila on Cinco de Mayo. He wasn't even thinking about this court case. Let's be
No, he
for
wasn't.
real.
He couldn't have been. He couldn't have been. An attorney who is truly practicing law and not just
Mm-hmm.
playing practicing law would have resolved that issue immediately. But of course, any attorney I know in good standing would not be using AI for his research.
Nope.
It just boggles my mind. Yeah, he's getting sanctioned.
yeah, yeah.
Sanction, fines, and
Yep,
maybe taken into custody.
yep, yeah. It's
Uh,
coming. It's coming.
I
I
uh,
mean,
can't wait to see this.
I
yeah,
think
I'm with you. Go ahead, Daryl.
I think he's gonna hit his pockets for about 10 grand or more.
Hmm.
Yeah. Well, I think that the sanction should be steep. I think he should have to prove and show uh 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 he should have to show what do they call it, a chain of custody for all of this stuff that he's claiming that he used, and when he realized that he made these mistakes and how he went about trying to correct these mistakes. Because you can't just say you did all of these things to the court. You have to prove these things, right? You just can't say you did it. He's
Mm-hmm.
going to have to prove that he realized his mistake on May the 5th and he went back and he filed all these corrections and all of this stuff. So show us some printouts of this, Tyrone Blackburn, because you're lying through your teeth.
Well, and not only that, how are you going to say you realized all of this? And like you had said, but in every filing, they were telling you were misquoting. The
Mhm.
judge
Hmm.
gave you the opportunity, 3 months in, to say, look, we're wiping the slate clean, no anti-slap, no whatever. Just do everything like according to protocol. File that you're his representation, and let's just start over.
Right.
So it's like the judge has been more than patient with him. Now, now the Pennsylvania attorneys,
Mhm.
are they, since they're basically his sponsor, they still can be acting attorneys at the same time, right?
I believe so, yes.
Yes.
According to my
Okay.
friend.
Yeah,
Yeah.
that's my understanding of Pro
Yeah.
Hakichi.
Yeah.
Yes.
Okay, so then there wouldn't have been any termination of him because, I mean, technically it's just your other two partners took everything over.
Well, and I told you all before, them other two partners was not reviewing Tyrone's work, and they
Right.
couldn't have been. And I told y'all, because y'all remember every video I kept saying, who's reviewing his work? I was like, he's screwing up. And the mere fact that we are now here having to say this again, but y'all do know TD Jakes' attorneys, they also filed a response already. So let me just show you guys this if you don't mind. I'm gonna show you this.
This is going to be good.
Yeah, because they've already responded. Hold on, let me see if I can get it up here properly. Here it is. Y'all stay where you are. Pursuant to federal rule of civil procedure, plaintiff Thomas Dexter Jakes respectfully moves for sanctions against defendant Duane Youngblood's counsel Tyrone A. Blackburn, filing briefs replete with false actual contentions, fabricated quotations, and gross misrepresentations of case law and the record. On May 5th, defendant Youngblood, through his counsel, filed a motion to dismiss and a memorandum of law. The opening brief falsely attributed language and findings to this court's April 25th memorandum, an opinion, including that this court had already observed the plaintiff's complaint to be repetitive and heavy on rhetoric. In other words, he was just insulting us and wasn't sticking to the law.
Wait, but May 5th is when he realized
Right.
everything. May 5th is look, Cinco de Mayo got a lot going on. Because
Yes.
May 5th, Tyrone saw the light, right?
Yeah,
Yes.
he didn't. Yeah, he didn't see
Yes,
the
the
light.
marvelous light. Yeah.
Yeah, but the burdens of his heart was not rolled away.
Hey.
Won't be at court where he really sees the light. But hold on. and lacking factual detail. Now listen, supporting the elements of plaintiff's claims, in reality, no such findings or observations were made by the court. The opening brief mischaracterized numerous other judicial decisions also, citing them for propositions that the case either did not support or outright contradicted, and in many instances fabricated quotes that do not appear anywhere
Mhm.
in the cited opinions. So what they're saying, if he's blaming ChatGPT and the new system that he used, he can't use that either because he put stuff in there that was
Put it in himself.
anyway.
Right. Yep. Mhm.
Okay, moving right along. Number 4, opening brief also made false representations about the complainant's content, representing that it does not contain various factual allegations that it plainly does. Plaintiff identified these misstatements in detail, providing specific examples of the fabricated quotations and mischaracterizations in his opposition. Rather than correcting or withdrawing the misrepresentations upon notice, defendant's counsel doubled down in his reply. What did I tell y'all earlier?
I didn't make a mistake.
What did I tell y'all earlier? Okay, let's move on. The reply continued to misrepresent case law and also falsely accused the plaintiff of misquotations and other legal inaccuracies. Supporting this claim with a LexisNexis quote check report that he failed to submit to the court and that plaintiff disapproved through manual review and detailed in his reply. All right, so y'all know what that means, this whole section right here. Guess what?
Mhm.
Ladies and gentlemen, TD Jakes' attorney says, we went back and checked his work. And
Yep.
we also checked the LexisNexis quote check.
Yep.
And we reported back to him and told him that he had messed all of this stuff up through a manual review and also in our reply to him. Okay, moving right along.
AKA someone else did the work for him yet again.
Right.
Mhm.
Counsel's conduct is not excused by any suggestion of inadvertence or inadvertence. The failure to withdraw or correct the material falsehoods after plaintiff first raised the issue in his opposition and again in his reply demonstrates a deliberate disregard for counsel's obligation under the Rule 11. And it's deliberate because, and y'all help me, Cigar Vlogger and Steph D, it can be viewed as deliberate because we corrected you, showed you we corrected you, and you then turned around and attacked us and told us we was wrong and you doubled down.
Yep.
You was running a fever.
Yeah, you doubled down. And many folks did not even appear in the legal source. So
He had legal flu.
So even if you want to use the fact that the computer did it, you can't use that the computer did it because some of the things that you quoted were not even a matter of law.
Right. He made them up.
He made it up. And what did I say? I hate to keep re-saying that. What did I tell y'all in all them other videos? Didn't I tell y'all he made it up? Didn't I tell you he made it up? I'm sorry to tell you. I said it. I say he is making this up.
You did.
I stopped even repeating and reading his responses because I told y'all he was making it up.
Mm-hmm.
Butterflies in the sky.
He lives in a fantasy world. He's sharing his fantasies with the court. What's the matter?
I cannot. No, that is hilarious.
To quote Mookie, this is the fuck flu.
Oh my goodness,
baby! I'm telling you, this thing so daggone messy. I just, for the life of me,
I will say this though. When I talk to the attorneys I work for on Monday, I'm going to be looking at them. I work from home because I live in Georgia. They're in New York, but I will look at them with a completely different eye and be so thankful that I work for attorneys who believe in the rule of law.
Yeah, this is
right.
This is hilarious, you all.
This is
and
right.
And he's doubling down, which is really what's hilarious. Let's go ahead and finish it. Let's finish this part. He says here, legal sources that are not found, they said nowhere online except in defendant's own briefs. They tell you right there he made it up.
He
And
made it up.
they said the facts that the fabrications are unmistakable. They said the facts that the fabrications are unmistakable. Moreover, counsel for the defendant had recently been admonished by another federal judge. So they're telling him, and they're telling the judge, Your Honor, he's been admonished by additional judges, and here is the court case that he's been admonished in over there in New York. So he lied, telling the judge he hadn't been admonished. So TD Jakes' attorney said he's lying again, Your Honor. He has been admonished, and here's where he was admonished. Here is the court case, and they're giving you the date. March the 25th. March the 25th. Is March before May?
It is on my calendar.
Okay, I'm moving on. For making misrepresentations of the law, he is also subject of a pending disciplinary referral in the Southern District of New York, and they list another case. That's on April. So in March he got hit, in April he got hit, and in May he got hit. I'm just saying, ladies and gentlemen, because I'm keeping track of the dates. All of the foregoing conduct violates Rule 11B, which require counsel to ensure factual contentions have evidentiary support and that legal contentions are warranted by the law. Given the severity of these sanctions are warranted to deter future misconduct and uphold the integrity of these proceedings. Accordingly, plaintiff respectfully requests that the court impose sanctions against Youngblood's counsel, Tyrone Blackburn, pursuant to Rule number 11. Award plaintiff all reasonable attorney's fees and costs incurred in responding to the motion to dismiss, drafting and filing the motion to leave. Now, in order for them to get this, y'all remember that they have to show up, the TD Jakes' attorneys, and I do believe TD Jakes himself has got to show up in court on the 24th or the 25th in order for them to get these fees, according to our previous document, if y'all remember. Yeah, they have to. He has to show up in order
to be there. Yep.
Right. Okay. And the part B, to impose any other sanction the court deems appropriate under rule blah blah blah. And this was the date from TD Jakes' attorneys. All right. So let's just continue. Let's just scroll through this. Here we go. Plaintiff's motion to support his Rule 11 motion for sanctions against, and then they list this, and then they list all of the case law. Y'all know how they do. They go through thing, blah 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 blah.
It's just so beautiful and organized. I always like it.
And so I mean, if you want to take the time, but there's one point in here, and I believe TD Jakes is turning, and I'm gonna have to have a part 2 to this because I hate going over 2 and 3 hours on the live. But we need to talk about this again because at one point, because y'all got to keep in mind this is 900 pages.
Right.
At
910 pages.
At 910 pages. At one point down here, you all, they put a calendar in here to show him, because y'all keep in mind that Tyrone Blackburn is telling the judge in the court, you didn't give me the proper amount of time to respond to this. So he's throwing the judge all kinds of responses. I'm looking for the calendar. Where is the darn calendar? They actually put in a calendar in here to show the times of when he was supposed to respond, etc. Okay. Hold on, let me go down here. Now, this is some lawyerly stuff that I don't have nothing to do with. I want to see that calendar. Hold on.
And the calendar is from Jakes' people?
I believe it's from Jakes' people.
Okay.
Hold on. I done dropped my whole thing. I'm sorry, y'all.
It went away.
It went away.
The judge only asked him for 15 pages. He came back with 910.
910.
He gave him 895 more pages than he asked for.
Well, he had a lot to say to back up all his lies.
Yeah, there's something I gotta show y'all. I'm trying to find this darn calendar.
But Daryl, I think your $10,000 mark might be correct.
Oh, it's gonna be more than that.
Normally, when a judge finds an attorney for something
Here
like
it is.
contempt, it normally starts at 10 grand.
He's in trouble. Oh, there it is.
There it is. Hold on, let me see. This is when they use the law as far as the Rule 12B requirements, motions matters, blah blah blah. This practice
Mm-hmm.
not discusses motions to dismiss failure to state a claim, can avoid Rule 12 attack timing for bringing the motion, pleading
Yes.
assertion and claim for relief, for a full listing of key content covering fundamental civil litigation, for general information and practice of federal court. He says options and the defense or failure to state a claim can be raised by a pre-answer motion under Rule 12B. Rule 12B, filing deadlines. Here we go.
There it is.
The
Yep.
time to file a response to the initial complaint controlled by Rule 12 after being served by the plaintiff's complaint and summons, unless another time is specified. A defendant typically has 21 days to serve and file either an answer or a pre-answer motion to Rule 12. To Rule 12. Now, to all of you legal minds, Steph and Daryl, as far as I understand, the statute does not fall under Rule 12. It falls under Rule 11B, not 12A, correct?
Mm-hmm.
Okay.
Mm-hmm.
Because what's being looked at here is Rule 12A, not the Rule 11B. Okay.
Mhm.
So maybe
Right,
I'm
right.
wrong. Maybe I'm wrong, but that's how I understand this. So his responding to the 21-day complaint, this is how he is justifying that he had extra time or he has more time. And I think on some level, I don't know if he's trying to say because of the holiday, the 25th, it wouldn't count or whatever. So he's trying to give himself an out for not responding in a timely fashion. That's my understanding. But I think he's going to be wrong all the way around because it's not 12B, it's 12A, it's 11B that he's supposed to be filing under. But I don't know whether or not this rule also governs Rule
Well,
11.
I think the 12B is what details what the filing deadline is.
Okay.
So
Yeah, the
while
11 I think is more
right,
of like
it's what
procedural.
right. Yes, because anytime a motion is filed, there's a timeline for when answers have to be filed.
Okay.
So I would believe that this is federal. I haven't done federal in decades, but it's my understanding that Rule 12 would be would tell you what the filing deadlines are. So
Okay.
you have a certain amount of time to serve something and a certain amount of time to respond to something.
But even if that is the rule, even under the rule of filing deadlines, it says unless another time has been specified.
Right,
By the
exactly.
judge.
By the
And the
judge,
judge
right. The
specified.
judge will tell you that. Yes.
So if the judge specified a specific time and you go past that time,
You are out of Yep.
you're out of pocket.
You're out. Right.
Yeah.
Exactly. And that's why, on my computer, I have a filing deadline calculator for that
Me
very
too.
reason. So yes,
You have
because
to.
you
have
got to
to.
do that. You got to do that because the court doesn't care if you file something 2 days late.
Right,
It's
because like
late.
the way that we used to set ours up on our calendar is we would purposely put them 2 days ahead of
Yes.
even what we think the
Yes.
response is.
Exactly. That's what we do too. Yeah.
A week out and then 2 days before.
Right. Yep.
Because anything can happen and you might have to do a last minute
That's
revision.
right.
Yeah,
That's
well,
right.
and a lot
I've
of
seen that
times you have
happen.
to ask for additional information because that's what a lot of my stuff was. In order for me to properly respond to your demand, I need additional
You need a time.
whatever from them.
Yes.
And if they don't respond with the additional request, then it's like, okay, well, I'm responding based off of what y'all presented and you
Right.
didn't present me enough. But yeah, like, no, those deadlines are no joke.
They're
Yeah,
not
but
a joke. Exactly. That's
but
serious business.
Yeah, but you're also asking if the time is not allotted, you have to ask for an extension or more time. You have to go to the
And you
court.
can request that. One of the attorneys I work with just had to do that. She had to ask for 2 extensions,
Yeah.
and the court gave it to her. But it's better for you to ask for the extension than to just file it late.
So
Yeah.
Tyrone Blackburn's whole case, you all, the computer made me do it. I just need y'all to keep this in mind. Keep the main thing. Tyrone Blackburn fired me. Y'all help me out. What was the third thing he said? After Tyrone Blackburn fired him, he said, what was the other thing he said?
There were 3.
Computer made me do it. Tyrone Blackburn fired me. The third thing was I forget what the third thing was. Good Lord. No, the fourth thing was God. Because at the end he
Oh
said
yeah,
it's
God.
God's
Yes,
fault.
I don't have enough time in the day. That's
Yeah,
right.
yeah.
Yeah.
That was the fourth thing. Because he said God don't give him enough time to do all his work. I'm just saying, ladies and gentlemen. I'll get my
Oh,
four
was it
things down.
him not having him working alone? Is
Yes,
that
Oh,
what it
that's
that
right.
was?
He
was it.
doesn't have
That
any
was the third
staff.
thing. Yeah,
That's
yeah,
it.
yeah.
Yes.
No
Yeah, let me
staff
write it down. Let me
for
write
his
it down.
living room law firm. Yes.
Computer,
Hmm.
computer, Duane, staff,
You know, I've known a lot
and
of
God.
attorneys who started out just, as solo practitioners thinking, oh, I can do this all by myself. Every last one of them now has hired somebody, at least one person, to work for them.
Yeah, yeah. Well, well, first of all, if you cannot do the work that you need to do, then you need to stop adding on cases. That's number one.
Right.
You should stop ambulance chasing and going
That's
after P.
right.
Diddy and going after all of these high profile cases. You don't get to come back and then later say the computer did it. This is a hodgepodge of mess. Sanctions are coming, ladies and gentlemen.
Mm-hmm.
That is
Yeah,
just
Mm-hmm.
and
that is just the bottom line. If the judge does
Yes.
not hit him with any sanctions, I'm gonna know. I want to see what the judge's response as to why he deems sanctions are not necessary. Because I have given you a litany of reasons as to why sanctions. He admitted even in his own filing that he did it.
Yes.
and
He
I don't
said,
get how that's not
I
bad
was wrong.
faith.
I was wrong. He said
Like,
it.
how
I
are
was
you going
wrong.
to say that you operate in good faith, but you knew all this bad, incorrect errors existed, but you're in
Mm-hmm.
good faith?
Yeah, no.
You should have asked for the extension and tried to drag it out.
Yeah,
Right.
yeah. He's a liar. The devil made him do it. The computer made him do it. Tyrone Blackburn fired him. He said he was on his way to correct all his mistakes. I want y'all to keep that in mind.
Did he say
Freedom
what
done
day he
lied
was
to him.
fired?
He
Oh,
said
I
on
thought it
May.
was June 23rd. He got an email June 23rd.
Well, he said, let's keep it before that. He said in the month of May, he recognized that he had made some
Right.
mistakes and he had already begun the research process in order to correct his mistakes. He said, but in June, he got the letter and then
Yep.
he started working on the stuff. But you said so May and June are our dates. He said in May he found it out, but then he turned around and said, "No, I didn't recognize it until June, until I got hit with the letter
Right.
saying that I was a fired
But
attorney."
I imagine he did not attach that in evidence that he was dropped.
No, it's
Because
here.
I'm just like,
Is that email attached to any of this?
Yes, the email from
Oh, it
TD
is.
Jakes' attorneys.
No,
no,
from
no, no. The one
no,
that says that he was
that fired
dropped.
him. Yes.
Oh, let me go through. It's 900 pages. I don't believe I saw it. Daryl, did you see it? Because I haven't seen it.
Mm-mm.
Because
Um,
I'm like, because my thing is,
Uh-huh.
anytime you make a contention, you have to supply the evidence.
That's right.
So he's contending that he was dropped, but where is the
Where is the
withdrawal
evidence?
letter?
Yes.
And
Let's
just
see it.
like how the Pennsylvania attorneys tried to say, in essence, Youngblood had nothing to, they don't know anything about this demand letter. Well, clearly a demand letter exists.
Right.
They have been in contact, per what Tyrone just said, for 9 months.
Mm-hmm.
So y'all both need to start getting your calendars together to
Yes.
make it make sense.
Yeah, because right now it doesn't.
not at all.
Mm-mm. Nope.
The whole case stinks to high heaven.
Yeah.
But I'm looking through I'm going through, I'm on page 59, page 60. Y'all, it's 900 pages. I'm scrolling as fast as I can scroll.
Yeah, you be here till Labor Day if you
I,
can't go through that.
Look, you better control find and try to type in
yeah.
withdrawn or
Yep.
no longer
Okay,
represent
hold
or
on.
Yes.
something.
I'll do it. Let's
It's
withdraw.
control 7 or control. Yeah, control.
Control. I'd use Control
Control
F, I
F.
think.
Yeah. Control
Yeah.
I. That's what I do. Control F.
Okay.
Yeah,
All right.
and
Let's
then you
go through.
type
Let's
in
go
the
through.
keyword. You type in that keyword
I
on there.
did. I typed in the word. Let's see. It took me all the way back to page 19. Oh, here it is. I'm going to all the pages where the word is listed. Let's go, Marcel.
Mm-hmm.
Let's go
Mhm.
down. I'm looking for that. No, these are all his quotations from them stupid briefs that he did. Hold on. Let's go down. Hold on. I'm serious, y'all. Everything coming up is these stupid briefs and the Nexus Lexus stuff that he used. Hold on. Let me go back down. Let me go back down. He ought to stop.
Has Satan
Oh,
lied to you?
Satan has
because
lied
I'm
to this
like,
man.
because I'm just like you. I would imagine in all those documents, I would sure hope in 800 pages of evidence,
It's not
you.
here. I don't see it. It's not
Uh-uh.
Yeah.
here.
Okay.
See,
So how
and
you
how's
gonna
he gonna
prove?
explain that?
Yeah.
I don't think he is going. Well, he gonna have to explain it when he stand
Yeah,
before the judge.
he's gonna have to.
Yeah,
You
yeah.
know what I think gonna
Because
happen?
if you were dropped around that time, why did your withdrawal letter then not come until June or if May and June? They dropped you somewhere in between May and June, but you didn't send a withdrawal letter until July 15th, 16th. Because you're
Mm-mm.
saying that you were dropped, but you requested to be withdrawn.
He
Correct.
tried.
He sure
So,
did.
Yes,
He requested to be withdrawn last month,
right, right.
but it
oh,
was
yeah, yeah, yeah.
June.
That's right. At the end
Yep.
of June.
I
That's
think it
why
was
the
At the
judge
end of
said no.
June,
Okay.
or something like
Yeah,
after
yeah,
that.
yeah,
Yeah,
yeah, yeah.
But
yeah.
keep in mind when he requested the requesting of to be withdrawn would have been around the June 25th date. But
Hmm.
yeah.
I'm thinking there was another time that he asked to be withdrawn from this case as well. And the
No,
reason,
no, 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 no.
huh?
Only one. Only
Only
one.
once?
Yep.
I only
So
remember one, but
that was right around my birthday. Cause remember when I said this was my early birthday present, and
yes, I
we all
remember
laughed.
Yeah,
that. Yes,
that's right. That was the
I
only
remember that.
time that I
Yes,
remember him
that's the
requesting
only
it.
time I remember too.
But
So
didn't
June
he
20.
ask? But in the beginning of this, see, this is why all of this is so convoluted for me.
No,
Because I could have swore in the beginning when he said he wasn't Tyrone, when he wasn't Duane Youngblood's attorney, and he
Yeah,
told
he did at the beginning. He did
no.
right,
say
In the
he didn't
beginning,
represent him.
right,
Yes.
listen.
yeah.
In
But
the
then he
beginning,
came back, he took the case, right? And then
Hmm.
at one point down the line, I thought, and I don't know, because it's been so many documents, and I hate to go through all of this again.
let me help.
But
Let me help.
Irene says he requested twice. I remember him actually asking to get off of this case before.
No, no,
Um,
no, no. Let me help you.
okay,
Oh, you mean when it first got
yeah,
filed?
No,
he asked.
no. Let me
Go ahead,
help you.
Daryl. Go ahead, Daryl.
In
I
the
could be wrong.
beginning, when Blackburn got sued, he had no representation,
Right.
and then but Blackburn was acting as de facto lawyer for him.
Hmm.
But then
Hmm.
about a week or two in, it wasn't even a month good. Then all of a sudden, Blackburn submitted the paperwork to represent him
Right.
because he had got everything cleared with that law firm in Pennsylvania, so he could come over and be Youngblood's lawyer. He never
Mm.
requested to be dropped. He requested and he submitted the documents to be added, not dropped, added.
Okay, okay.
Now
Yeah,
on
because
my
I
birth,
think at first, because maybe it was back to when it was like, oh, I'm not his legal representation, go pound sand. Maybe it was
Hmm.
that.
that's what happened. That's what
Yes,
happened
that
because
did happen. I remember that. Yeah.
on my birthday last month is when he submitted the paperwork. But now he's claiming that Black Youngblood fired him. So if Youngblood fired him, there's no need for you to submit to be requesting to be dropped
Nope.
from the case if you've
Because you
already been
done.
fired. You've already been fired.
Yep, you're done.
Yeah. So he's lying.
Put it like this:
Yeah, he's lying.
the judge may let him go. The judge, when he has to show face at the end of the month, next or end of the week, the judge gonna be like, "Look, I'm gonna let you get off the case, but not before you pay up." And he
And
gonna let him know you owe the
Yeah, he's
court,
gonna. Yeah, he's
the
gonna have to
plaintiffs.
pay.
Like you can go do whatever you want, but just know this bill gonna be hanging over your head.
Hmm.
he's
Now
not gonna be able to
understand.
get out until he pay that money.
Well, here's
Judge gonna
another
hold
thing
him.
too, Daryl. If TD Jakes' attorneys show up, he's got to pay TD Jakes' and his attorney fees and all of
Exactly.
that.
That's right.
Exactly.
Yep, that's what I
That's
Exactly.
why
mean.
it's gonna be
It's gonna
over
be a hefty,
10,000.
hefty sum.
Yeah, it's gonna be well over 20,000 when
Hmm.
you add all the attorney stuff
All the
in.
Oh
attorneys.
no,
That's
no,
right. Because they
no.
each get a
No.
pay. They'll each get an hourly rate.
Oh, you lowballing.
Hmm.
When I first did this thing and I calculated $600 an hour. You got how many attorneys Jake's got? He got
That's
four,
Four
didn't he?
now.
Is it four? Oh, I thought it was more than that. Okay.
So you count up four lawyers at $600 a pop per hour Plus, each
That's
one of them
still a
gonna have.
lot.
Each one of them has 2 paralegals. Paralegals gonna
Right.
get you
The
about
paralegals
300
get
an
paid
hour.
too. That's
So you're
right.
looking at 30. 900 times 4, you're looking at $3,600 an hour for them to represent, and they've been on this since November.
Yes.
So they got to pay. He's
Oh.
got to pay them people up all the way from November to July.
I can't stand Irene. Irene say he on food stamps. He get a bonus.
He's looking at hundreds of thousands of dollars. He's looking
Oh,
at hundreds of
Irene.
He's looking at hundreds of thousands of dollars. And what the judge will do to be sympathetic, he said, well, he's not going to have him and pay 100% of it. He'll probably make him pay 60% of that. That's still
Hmm.
hundreds of thousands of
That's still
dollars.
a lot of money. That a
You are
lot
a
more than he
law,
Wow.
got.
and when you are a living room law firm with no paralegals, no assistants, your ass is stuck. He's going to have to get out there parking lot with CTV and bust it wide open. He's going to have to get that money.
He'll be
Bust it
running his
wide
law
open,
firm
then
out of his
Hella bring it
car.
back.
Because
Oh
he's stuck.
man.
Now you think about it. Now he got to pay them back because the judge gonna say, "Yeah, you got to pay these legal fees."
Right.
Then he gonna be held in contempt. That's probably
Yep.
another 10 grand. And
Right.
mind you, all of this is in Pennsylvania. He hasn't even dealt with the fact that he tried to run over a process server in New York, and that's
Yes,
a felony.
that's right. Yes, there
Right.
is
Well, and then
that.
that was going to be my other question in regards to these timelines. Sir, when was you doing all this hard work when you was too busy running over
Running
people and
people
going to
over.
jail?
He wasn't doing any hard work. I'm gonna tell y'all, like we said from the beginning, this was all Chat GPT.
Yes.
He gets to blame AI. Now
Hmm.
let
No,
me
it's
refer back to
computer.
my list because I had to keep my list.
He
He
blames the
blamed the
computer.
computer. He blamed Duane Youngblood. He he blamed the fact that he don't have no staff, and then the nigga had the nerve to blame God because he don't have enough time in the day to do all his work.
And Marcellus, you know why he didn't have enough time? Because he was out at that courtroom almost every day at that Diddy trial, and
He
he
sure
went into
was.
the
Well, no wonder.
He
room
sure
and got
was.
he
He was out there with
got
a
it legit.
backpack on, talking to
Hmm.
Armand Wiggins. Y'all
Yeah,
remember because Armand Wiggins say Tyrone Blackburn. Y'all
How does
remember?
it feel?
and remember,
Wow.
Blackburn got thrown out of the Diddy trial because he wouldn't shut the hell up.
That is correct.
Yeah, causing
I
a
do remember
scene.
reading that. Yes.
Yeah, and not
But he
only
got
that.
all that time, but he ain't got time to get his paperwork in on time.
Yeah,
Right.
and listen here, I called it three line mice because you got Duane Youngblood,
Hmm.
you got Tyrone Blackburn, and
Hmm.
you got co-conspirator number
Hmm.
one. Now
Yes.
y'all listen to me carefully. Regardless of how you think or how you feel, co-conspirator number one is also implicated in all of this mess as well. Because
Hmm.
brought these liars up on it. He brought that liar up on his platform, and he had been lying for over a year regarding TD Jakes. Now, I want to reiterate this point as well as we get ready to close. I'm getting ready to close. Hold on.
Wow. Who hit the
Listen,
organ? Hit the
That's
organ,
what I'm saying.
Daryl. Hit the
Somebody get the
organ.
organ going.
listen here. As I get ready to close, y'all listen to me carefully. Larry, Duane Youngblood, and Tyrone Blackburn, in our opinions, as we have seen this, they have been doing this. Larry has been talking this way for over a year about TD Jakes. He done called all TD Jakes all kind of names, said he was a groomer, said all of this other kind of stuff. He
Yep.
brought this man up on his platform twice to tell these stories about a hug and a potential kiss, right? They have not brought any evidence into this courtroom to prove that this has happened. Co-conspirator number one he's trying to do everything but address this. He done doubled down on his statements about TD Jakes. He said TD Jakes was dumb and TD Jakes was all of these other names and all of this stuff that they call. Y'all need to keep that in mind.
Yes, rat-a-tat-tat.
Hmm. Yeah.
We was all dumb. Y'all remember that?
Hmm.
We didn't know what we were talking. We were slop bucket vloggers.
Right.
Daryl, we
Yep.
was YouTube uploaders.
Touch your neighbor and say YouTube upload us.
I'm just saying.
And the
This is
church said amen.
amen. This is not checkers, ladies and gentlemen. This is chess.
Yeah.
This is a divine game of chess, and TD Jakes is winning.
Yes, he is.
Now you go run tell Reverend Scrotum Sniffer what I said. You go tell that tier 3 sex offender, tier 3, keep that in mind. That what
Mhm.
you go tell them what I said. What you all did was wrong. You know you was wrong. You had no business bringing this case on this man. Even if this man had done what you said, you still don't have no evidence of it.
Right.
And that is the problem. That is the crux of the matter. I'm just saying. Sorry, y'all. The game is over. It's over. The game is over. And then this other attorney that now done took over for Duane Youngblood, his whole refiling of it is we can neither confirm nor deny. He said it through the
Yes.
whole court case. You know why? Because he know he don't have no evidence.
There's nothing there.
There's nothing there.
Trouble.
That's all I have to say, ladies and gentlemen. You all can give your final thoughts. We roughly coming at 2 hours and 40 minutes. Daryl, I'm gonna start with you, sir. What are your thoughts on this? Or you can keep talking if you want to. I just know I'm done.
$10,000 starting out, court costs, fines, possible jail time.
Well, Duane Youngblood needs to go back to jail. And I want y'all to understand something. Y'all, the saints make me sick feeling sorry for all of these people, because we're loving people, and we love people because the Bible tells us that we're supposed to love our neighbors. We love ourselves, but I love myself so that I don't bring frivolous cases up on people. I didn't bring a frivolous case up on my employer. My case was not frivolous. That's why we went all the way to federal court. Because it wasn't frivolous, and that's why your judge said, bring this on up in here. You don't bring frivolous cases up. You don't treat your neighbor like this. You don't do this. When I told y'all that they needed to leave that preacher in Idaho alone who married that 18-year-old girl, and I told you that was a stupid case and everybody needed to leave it alone, people accused me and y'all jumped all over my back talking about, oh, you trying to out church me and you trying to do that. I didn't even know that was a thing. I don't even know how you out church people. I'm trying to inform you, just based on the little bit of knowledge that I have. You don't bring these frivolous cases to people. You don't do that. Mary, what are you supposed to do with this? What you supposed to do now? What we supposed
I mean, from the beginning, we have all said it, that it's an insult, and I'll continue to say it is an insult to the victims. The person that he is going after is not even the person who actually SA'd him, according to his story. One of them has passed, yes. The other one, who is alive, he has not brought forth any demand letter to them. So what say you there? Oh, you were going after money bags. But yeah, it's still a continuous slap in the face to real victims who, and I mean, considering he's saying he was a real victim, but he's going after the wrong abuser in this case. It's sickening. What we are seeing is exactly what is expected. They thought they could lie and crook and scheme all the way through it, but they got the right one. They got the right one.
Steph?
I'm listening to all this and I'm thinking, his original plan was to try to blackmail $6 million out of TD Jakes.
Mm-hmm.
And this is going to go full circle. And he's going to end up paying TD Jakes a whole lot of money. So, I'm just going to sit back and watch the show. I think it's insulting that they have done this to TD Jakes. But I think that, like she said, they picked the wrong one.
Yeah, I agree. I think Tyrone Blackburn is a joke. I think that what he is doing to other lawyers in his profession he's making a mockery of the legal system. I think that he's just throwing things up at the wind and hoping to land on something. But I'm also going to submit to you all something here. Because see, it's almost like a sleight of hand sometimes. When we're too busy concentrating over here on one thing, something else is done. Now, y'all may not believe what I'm about to tell y'all. But that whole thing between Larry and Bernard Jordan, I think it's contrived and derived from them trying to create a causation of space between him and Larry and so that the focus can be off of Manasseh Jordan and the statements that Manasseh Jordan and Larry Reid made for over a year. Because you notice nobody's talking about what Manasseh Jordan and Larry Reid did anymore because of the separation between quote unquote Bernard and Larry. Now we
Well,
talk,
us in the comments definitely make sure we remind it all started with that episode.
but I think with the lawyers and these people, there that the separation was to create the distance so that people would not focus. Because what was I doing? I was bringing out whole charts to y'all, telling y'all, I had a whole connect the dot and arrow chart. Y'all remember it? I don't even have it up on here. But the dots were connected. And I think that in totality, in order for this case to really be looked at like it should be, you need to go all the way back to Manasseh Jordan and come all the way forward. In order to really get the information that you need to look back and then come forward. Because Larry made a lot of statements as co-conspirator number one that were not listed in any of these documents. And it's quite concerning to me that those things were never mentioned in these documents. And I don't know whether TD Jakes' attorneys will use that as ammunition later when Larry is on the stand going, a hubba bubba. I used to eat hubba bubba when I was a child, because that's what he does. Every time Larry gets in the court, I'm trying to tell y'all, he gets bubba bubba bubba. I don't bubba 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 bubba. It's a hubba bubba moment.
Yeah, well, and I think that they are kind of holding on to those things, which is why I know, like, in the background, people have been wondering, like, who's going to possibly be listed as witnesses, is because all of his sounding boards came in double stamped and triple stamped all of his assertions, and CTV said he even saw with his own two eyes some of this alleged evidence. So it's like they're definitely holding stuff back.
That idiot said, and I didn't download the video. I should have downloaded the video. That idiot said he saw a check. Oh, I remember what he
Oh, I
said.
remember him saying
Yeah,
that.
that's what I'm
Yes,
saying. He
yes,
saw
he
with
sure
his
did.
own two
Yes,
eyes.
yes, he did say that.
He said he saw a check that TD Jakes had paid somebody
Mm-hmm.
to be silent.
He pay a lot of people. Let's be for real.
That's what he said. I'm just saying. There's a lot
Because
of
the check easily could have been for, oh, he performed at whatever conference we had for that month. It's like you could see whatever checks you want, but
Mm-hmm.
unless you saw a contract or the NDA or whatever, the check don't mean nothing without
Right.
that.
That's
What
right.
was the settlement agreement? Did you see the settlement agreement?
Mm-hmm.
I don't know. I pinned the link for anybody else that wanted to say your piece. So I guess if you're not up here, you didn't want to say your piece. All I'm gonna tell you is this to all of you that are listening and watching. I'm a reverse Uno this. Larry's dumb. Tyrone Blackburn is dumb. Duane Youngblood is dumb as hell. Richard Youngblood and all of these affidavit writers are dumb. This entire case is stupid. And TD Jakes had more than a right to file this, because y'all have to keep in mind now, according to Duane Youngblood's attorney, who is now working on his behalf, he's now stating there was never a $6 million demand letter. We just all arrived here. Just, I was sitting the other day, I swear to you all, I was thinking and laughing to myself. In them Disney cartoons where the little fairy we'll have a magic wand, have a little star at the end of the magic wand, and they'll start. I'm serious. They'll start waving the magic wand, and they will go bippity boppity boop, and then they'll they'll hit the little thing, and then all of a sudden it just changes. I swear to you, these people work all kinds of magic. They doing a bippity boppity boop in this legal case, and they're trying to make us think that we don't know what we know, and there's things that don't exist. So here lies the dilemma now, Daryl, and for all you legalese that are up here with me. Are you guys trying to tell me now that Duane Youngblood's attorney is going to say that Tyrone Blackburn submitted that letter to TD Jakes without Duane Youngblood's knowledge?
That's what the other two lawyers are trying to imply.
That's what it sounded like. Yep.
That's not gonna work either. You know how that's not gonna work?
There's a whole video of the demand letter having been sent out to people. So how did Youngblood not know? But there was a whole video of co-conspirator number one saying, "And I received the top of this
Mhm.
letter."
Yes.
Not only that, when was Duane Youngblood going to announce to the judge that he never submitted a $6 million request in all of the filings? Because let me explain something to you. As a person who's been through the legal process, and I'm gonna tell y'all my funny story in a minute. I forgot now. Thank you, Lord, for reminding. I've been through this process. When these people submit papers to the judge, they give you copies as the person that they're representing. So you
Mhm.
have to review it and look it over yourself. They don't just submit these paperwork to the court. Now I don't know whether or not that he was required to sign off on what they submit to the court, but I know in my case, I had to go through the interrogatories. I had to go through
Mhm.
the documents and say, okay, this is pretty much what I said. This is what I agree with. So you mean to tell me since November of 2024 up until June, when your lawyer was fired, you didn't have a clue that a $6 million request was made, even though the attorneys has been telling you since November of last year that a $6 million request has been made? Miss me with that one. Y'all are full of it, and I hope the judge sanctions all of you, Tyrone as well as the other attorneys, because y'all should have been checking Tyrone's work. You let him use Chat GPT and deceive all of these people, and that's just foolishness. Now on to my story, and then I'm gonna end. I had a neighbor one time. Now this is a little bit of a different type of case, but let me tell you what happened to me. I got sued. I think I might have told Daryl and the moderators this story one time. I used to have a couple cars, right? And so I was trying to get rid of one of the cars. It was an old 1980s Toyota like hatchback thing. I mean, it was an old car. When this car was so old, the battery was being held up by a shoestring. I ain't lying. It was an old car. This car was so old, when I step on the brakes, the headlights came on. I'm kidding you not. It was an old car. I took it to a man. He was rewiring it of the rewiring. I mean, it was serious rewiring. So I said, you know what? I'm sick of this car. I want to get rid of this car because I don't do nothing with this car anyway. So I need to get rid of this car. So I went to my neighbor. I said, hey, would you like to buy my old car? I think I sold him the car for like $700 because the car was a raggedy car, right? Stepping on the brakes and the headlights coming on, it was a mess, right? So I was like, okay, I'm not gonna try to gouge the man. So I made him sign a document. He bought the car, whatever. So the man took my car, drove my car for days. He was moving furniture. He was doing all kind of stuff with this old car, right? After he got done moving the furniture stuff, he came and knocked on my door and said, I no longer want the car anymore. Me being the Negro I am, I said, well, that's not my problem because I done sold you the car. You done signed off on this document. I'm not taking the car back, and I'm definitely not giving you any money back. The man cussed me out. I mean, he lit into me all like you couldn't believe. And so I shut my door pretty much. I told him thank you, but no thank you, and closed the door and went on about my business. So in the middle of the night, he came and taped the car key and a piece of paper saying he had returned the car to me because he parked it behind where we lived. And he said, oh, it's no longer my car, but he left the key on my door. I said, oh, this ninja think he's sharp, right? So I said, let me pull one of his stunts. So I took that same key, I wrote another note, and in the middle of the night, I went and taped it back on his door. I said, because it's not my car. So we had this little tit for tat thing going until he sued me. My cousin Sherry went to court with me. And I'm so glad for the Holy Spirit, because I don't care what nobody say. The Holy Spirit will lead you and guide you, not just in the Bible, but in every area of your life if you let him. So I go into court. I'm just pleading my case. The man starts talking and saying too much, like Tyrone Blackburn did in this document. The man talked so much, the judge looked at me one time and he said, Marcellus, are you saying that this gentleman owes you more money and you need to get more money out of him? That's what the judge said to me, Daryl. Now, right then, if I wanted to be grimy, Like Jamal Bryant's baby mama says, if I wanted to be a grimy person, I could have told the judge right then and there he owes me more money because of the way that the paperwork. Oh, that's what happened. When you go to the DMV and you sell a car, if you put a lesser amount down on the paperwork, when you turn the paperwork into the DMV, the fees are lower. They're cheaper, right? So he asked me to fill out a receipt for a cheaper amount. I'm just saying, so he could get lower fees, right? So I gave him the paper. I gave him what he asked for, but he gonna bring that into court talking about, oh, this is what I paid. And I said, no, the actual document that he actually filed and that I have on file is this paper. So the judge said, oh, well, you're saying, Mr. McMillan, that he owes you more money. And I could have told the judge right then and there, yeah, this dude owed me more money. But here's where the man made his mistake. And here's where Tyrone Blackburn has made his mistake. He starts talking crap to the judge. And I don't care what nobody say. This whole refiling that this man just did right now is talking crap to the judge. He is thumbing his nose in the face of the judge. I know it was Chat GPT, but Judge, Your Honor, it shouldn't matter because you need to consider everything. I was under a lot of pressure. I did it. My computer failed me. Duane Youngblood fired me. I ain't got no staff. God cut off all the time because I didn't have enough time in the day. He just thumbing his nose in the face of the attorney. He just talking. So did the man in my case. The man told the judge, he said, well, at one point he told the judge, he said, well, I am a collector of cars and I know when I buy a car, whether the car is good or bad and da. You know what the judge did? After he made that statement, the judge hit the gavel so fast. You know what the judge said? The judge said, then you should have known what you bought. You should know what you bought. If you're a collector of cars and you know all of that, mister, I'm a collector of cars, then you should have known what you bought. He hit that damn gavel so fast, y'all. Before I could blink, the gavel had been hit. And he said, he awarded me by case. Boom. He hit the thing. And as I was opening up the little wooden door to exit the courtroom, my cousin came up on side of me and she put her shoulder to my shoulder. And we were leaning on each other as we was laughing as we walked out.
And what I know that's right. Ego will get you every time.
It got him. And Tyrone Blackburn's ego is going to get him here because he done lied about these dates. He done lied about the citation and the quotations of the court. He done admitted in this court filing that he knew what he was doing. And he made errors, and he also admitted here that he had time enough to correct his errors and to notify the court, and he did neither of those things. So here's what I want to tell you right now. Everybody need to get their money up because there's a couple of things that can happen here in this scenario. The judge can hit Tyrone Blackburn with the citations, send Tyrone Blackburn on his way, because to be honest with you, I think, well, I guess the judge can't the judge can force him to stay on the case if he really wanted to, Steph. The judge really doesn't have to let him out.
No, I guess the judge could. I mean, that's true. I mean, I don't know how it works in federal court. I just know in family court, when if someone decides they want to change attorneys or they want to be pro se, all they have to do is a notice of withdrawal or notice to change attorney.
I need to call my friend, because if you work pro hoc vice, the other attorney is the mainline attorney, but you are also an attorney on file and on record in regard to the case. Now, they may be able to dismiss him or whatever, but even if they dismiss him, this other law firm is going to have to continue with this case. And they can neither confirm nor deny anything. And according to these people, there's no such $6 million request letter. They're saying there ain't no letter. We just all arrived here by bippity boppity boop. Bippity boppity boop is how we got here. And voila, we got a case with one of the largest preachers in America.
They woke up to that lady in the red dress singing, surprise, 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 surprise.
Y'all, I'm over it. God bless every single one of y'all. Please hit the like button. I have delivered to you all some information, and I brought it to you in the best way with full confidence that I know how. I'm trying my best to keep you updated. If you are supporting the Mad Church Disease channel and you're watching the replay, the support links are in the description below. The Cash App information, of course, the moderators will put in the chat if you would like to support my platform. And I'm going to leave everything there for now. I'm gonna leave it there. I'm gonna leave it there for now. But good luck to TD Jakes and his attorneys. God bless Mary. God bless Steph D. Thank you for coming up. I appreciate every single one of you all. Thank y'all for participating and helping me get through the maze of this situation. And oh, what a maze it is. And oh, what a maze it is, ladies and gentlemen.
Yes.
This is a maze. This whole case is a whole maze. But God bless y'all. I appreciate every single one of y'all. Shout out to you all that are watching the Mad Church Disease channel. Shout out to every single one of y'all. We are working hard over here. I need for y'all to understand. So keep supporting the channel. I appreciate every single one of you. God bless you. And the only thing I could say to you, Tyrone Blackburn, this has been an F around and find out moment. You're about to be hit with sanctions. And the only way the judge doesn't hit you with sanctions is the judge has to have mercy on your soul. And he going to have to leap past a whole lot of legal precedent in order to not hit you with sanctions. Good luck. And Duane Youngblood, you sure got rid of this lawyer just in time. That's what makes me think this is a whole conspiracy. Because how you get rid of your lawyer just in the nick of time like this? Y'all hit the like button on your way out. Thanks everyone for watching. Your support means the world to us. Please make sure that you hit the like button and please make sure that you subscribe to the channel and make sure you hit the bell icon and make sure you press all notifications so that way you will never miss any of the exclusive content that comes on my channel. Make sure that you never miss a video. Now, I try to go live every day about 2:30 Pacific Standard Time, which is about 5:30 Eastern Standard Time. And then I come back at night at around 8:30 Pacific Standard Time, which is about 10:30 Eastern Standard, with some more exclusive content. So if you want more Mad Church Disease show content, we'd love for you to become a member, a revolutionary member of our channel. Please make sure that you hit the join button that's right next to the subscribe button or somewhere around here so that you guys can receive access to special community posts. You guys get all of the access to my community only lives because we've got some sipping chats that we're going to be doing, and you guys will get exclusive content. So just make sure that you head on over to the channel page, click on the join button, and make sure that you do that. Thanks again for watching. I appreciate your love and support, and I'll see you on my very next video.
We are Mad Church Disease, helping you understand that Jesus plus nothing is everything. This is a show for everyone, believers and non-believers, from churched to the unchurched. Help us grow the channel by supporting our non-profit causes and create more consistent content. Donate by Cash App or PayPal, or buy us a coffee at buymeacoffee.com.